Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 4th, 2025. We have 11 bills on the docket. I see Senator Jackson is here, so we're going to start off with Senate Bill 766. Senator, you want to bring up your panel?
Thank you very much, Mr. Chairman, Mr. Vice Chairman, and members of the Judicial Proceedings Committee. For the record, Senator Michael Jackson, District 27, on behalf of Senate Bill 766. Senate Bill 766 expands the jurisdiction of our Maryland Capitol Police to include statewide enforcement activities. The legislation came to me in conversations with the Department of General Services. We have the Secretary here with us today. I will be turning it over to him shortly, as well as the Maryland Capitol Police Chief, Mike Wilson, and his team. The aim is to expand and to clarify the authority of our Capitol Police to better achieve their public safety mission. Mr. Chairman, we're looking for a favorable report. We're certainly here to answer any questions, and we appreciate your having us here today. So I will reserve my time and turn it over to the Secretary of the Department of General Services.
Thank you very much, Senator. Welcome, Mr. Secretary.
Thank you, Senator. Mr. Chairman, esteemed members of the committee, for the record, I am Latif Chaudhry, Secretary of the Maryland Department of General Services. I want to thank you for the opportunity to be here before you today. At first, I want to start by thanking Senator Jackson for sponsoring this bill, and also I wanted to thank Delegate Simmons for co-sponsoring the cross-file of this bill in the House. I want to appreciate the opportunity to discuss this particular bill, which I'm very particularly passionate about, and wanted to give a little bit of background on the bill and just provide a little bit of detail associated with it. It is a cleanup bill. It does clarify inconsistencies. It removes previous listings for jurisdictions that have been added over time. It does clarify that MCP has jurisdiction over state-leased and state-owned facilities, and it does expand the jurisdiction currently 1,000 feet beyond the state occupancy to 2,000 feet. And there's lots of reasons for that, which I'll let the chief and deputy chief go into but one of the most important things here is it does provide statewide jurisdiction across the state and allows MCP to operate with local law enforcement entities. And we are respectfully requesting a technical amendment to add parking and motor vehicle law enforcement as well. And the current jurisdiction is across 1,400 buildings and nearly 400 leases across the state. This will expand that across the state to be statewide. And MCP has done increased collaboration with local law enforcement, particularly in Baltimore City, in Annapolis, and Anne Arundel County. And we're providing right now, just as a prime example of that, MCP is providing safety and security to state agencies relocating out of state center. And we are partnering with the Downtown Partnership, Baltimore City Police Department, UMB Police on a strategic operations center in Baltimore City. Lots of jurisdictional issues can come about when you've got a 1,000-foot perimeter around buildings. And I'll let the chief and deputy chief go into those challenges, but they can be significant. I know in my time here as secretary, I've seen some challenges on some serving criminal warrants, et cetera, which is beyond that. So this clarifies and does provide the necessary and requisite jurisdiction for statewide law enforcement that all other state law enforcement agencies have. So thank you. We respectfully request a favorable report on the bill.
Good afternoon, Mr. Chairman and members. I am Deputy Chief Lieutenant Colonel Glenn McGuire from Maryland Capitol Police, and the Maryland Capitol Police has increased its footprint and responsibilities that as we continue to grow, as more active involved in enforcement with traffic and parking, as well as criminal laws in many different locations throughout the entire state. The proposed changes will enhance the Maryland Capitol Police capacity to ensure a safety and working environment for our state employees, as well as strengthen the ability to secure critical infrastructures. We also need to improve the department's effectiveness in responding to critical incidents, again, throughout the state. So Maryland Capitol Police intends to establish MOU agreements with the local and regional law enforcement agencies to familiarize and cooperate with the various agencies, clarify roles and responsibilities, and ensure the smooth operational integration across the state. In addition to that, we can maintain the relationships with these various agencies, as well as we offer our assistance in the various agencies throughout the entire state. So that's additional support with additional resources. Some of the current challenges, currently it's 1,000 feet from our properties and our buildings. We're looking to increase that, which is 1,000 feet is 0.2 of a mile, and then 2,000 feet is what we were looking for, will be 0.4 of a mile for the jurisdiction. That at times becomes challenging and confusing to the officers trying to do their jobs and enforce the various activities that they need to address. Delayed response to the citizens is one of the concerns that we actually have if we do not have this in place. And confusing issues with court proceedings as well. So that's another concern that we have, because if they're not sure where the jurisdiction occurred, then it could be a problem in court. Minimizes the law enforcement resources that we have to include the ability to serve criminal summonses, arrest warrants, and things of that nature, as well as condition checks on our wellness of our employees. And last but not least, I'll also add the ability to participate in multi-jurisdictional investigations with our allied agencies. So thank you for your time.
Thank you.
This is high as this goes, huh? Good morning, Mr. Chair and committee. My name is Mike Wilson. I'm chief with the Maryland Capitol Police. And I just want to elaborate a little bit on what you heard from the secretary and from the deputy chief, and tell you a little bit of things about the department I don't think that people realize and understand, and the reason we're asking for a statewide jurisdiction. One of the things is some of the things we just did was we implemented the K-9 program a couple years ago. We have bomb explosive detection K-9 teams. That they continue to be the standard for the state explosive detection teams in the state. We have 6 teams right now, looking to add a couple more. But these K-9 bomb explosive teams travel all over the state during different capacities and assist other agencies. We do training and with Maryland State Police, with Anne Arundel County Sheriff's Office. We do training with the Annapolis Police Department. These dogs, you might see these dogs at the Ravens game. If you go to the Ravens games, a lot of our dogs are up there, the Orioles games. We assist the United States Navy Academy down here on many occasions with football games, with the naval graduations that occur here every year, special events that they have, and we also assist with, last week we assisted with a bomb threat that occurred over in one of the buildings with the Naval Academy. So they do notable events down in Baltimore City, and we also certainly help Annapolis City with many of the special events that they have here, to include the football games as well. So and we help, we assist MSP and the fire marshal with bomb threats throughout the state. I'll just give you a description of kind of some of the things they do. Last year they scanned almost 2,000 cars, handled 130 unattended bags, helped us out with 26 different rallies here in Annapolis. We assisted other agencies 32 times on calls for service. They go to many demonstrations and community contacts with schools and with kids and everything. We scanned explosive and firearms 5,185 times last year. We're called out 17 times for bomb threats, not necessarily associated with Maryland Capitol Police, but other state agencies and municipalities. So the K-9 teams are a big part of what is added to us. Some of the other things I don't think that people realize that the Capitol Police are involved in is not just in Annapolis and Baltimore, but we also handle many other different functions over the past years. One of them is the Strategic National Stockpile. Don't know if you...
Excellent. We actually have some questions from the
okay.
Sorry, yeah, no worries, the time's elapsed, so I just want to make sure that, just out of fairness for the panelists, I want to make sure we keep it. Senator West, go ahead.
Thank you, Mr. Chairman. So my questions may allow you to elaborate on your testimony.
Okay.
I'm worried about mission creep, and I'm worried about stepping on toes. So I'm looking at the website for the Maryland Capitol Police. It says they will provide a safe environment for all visitors, employees, and government leaders at our facilities and state office centers. And now this bill says that the police may investigate and enforce statewide the criminal laws, which sounds like a massive expansion of what the Capitol Police are supposed to do. I'm concerned about you all in launching investigations and stepping on toes of existing investigations that other law enforcement agencies are engaged in. So far, all I've heard about your involvement beyond the missions stated on your mission statement is your canine teams. And you were about to get into talk about other respects in which you currently assist, and emphasis on the word assist, other police organizations. So could you continue with that?
I can. And to talk about the, expansions of the department and additional responsibilities that have occurred over the last couple of years, we are also involved in the State Law Enforcement Coordinating Council, which was just part of a statewide mobile field force that's used during statewide emergencies. For example, in 2012, Capitol Police assisted with that select force and with Camp David presidential summits. In 2015, our officers were in Baltimore City for the civil unrest that was due to the Freddie Gray arrest. 2019, we were assisted with COVID-19 and the state emergencies that occurred in the Baltimore Convention Center and hospitals that were built up. Some of the other things that we do is with with the merger of DLR police force that happened not that long ago, we acquired additional properties throughout the state. Our officers now respond to multi-jurisdictional court centers and stuff, multi-service centers throughout the state of Maryland. We don't do it on a regular basis, but we do it when asked and when things occur at those facilities. So there's the expansion of the department, and the stuff that we have been doing has expanded throughout the whole state. And that's the reason we're asking for this jurisdiction mostly.
All right, so now I've heard you use the verbs.
The Secretary want to add?
Yeah, Senator, I was going to add, just add a little bit to that, if I may, that currently the current jurisdiction is we've got 1,400 state facilities across the state, 380 leases across the state. So their jurisdiction already does go nearly statewide. It's just to help clarify when it comes to 1,000 feet. It can be confusing for law enforcement to say 1,000 feet beyond a building, how far can they go? We are coordinating very closely with, to the chief and deputy chief's point, in Baltimore City, we're coordinating on a strategic operations center on the downtown area where we may be, if we're in closer proximity, we will respond to crimes in lieu of Baltimore Police Department or UMB Police Department. So we will be able to respond faster, when crimes occur. We're all going to be sitting in the same room in the strategic operations center. And also, it will help, to effectuate issues that relate on the campus or close to the campus, meaning welfare checks on employees, serving criminal warrants, serving criminal summonses, things that occur in their normal law enforcement capabilities that they will be able to do. Also, traffic enforcement, while they do that adjacent to our buildings, be able to do that more in a broader area, in a broader aspect.
All right, let me toss in another question, and maybe, Mr. Secretary, it should be directed to you. I've heard several times the verb assist, and at least once the phrase when asked used. Would you be willing to accept an amendment to the bill which says you may investigate and enforce statewide the criminal laws in order to assist other duly constituted law enforcement agencies in the state, or when asked by other duly constituted law enforcement agencies of the state, which would limit your function to more of a reactive one rather than a proactive one, with you going out and on your own deciding to initiate investigations? Would that be an acceptable amendment to the bill?
Well, Senator, the only concern is we don't want to stifle their capability, beyond Capitol Police's capability to respond in any type of an incident that they deem necessary. So while we do support in many aspects, a lot of times we might be taking the lead on certain issues, thefts, assaults, other things of that nature that do occur. They don't, and there is a thing in the bill for notification and coordination. So our goal is going to be in the jurisdictions where we normally coordinate on to have MOU agreements with our local law enforcement entities. So we have that collaboration and understand where the lines are drawn and to understand where the collaboration will occur.
Okay, I understand what you're saying, but we already have a Maryland State Police. We certainly don't need to create or to expand another organization to basically compete with the Maryland State Police in enforcing the laws. or to compete with local law enforcement authorities. And that's my concern. My concern is you're going to have various people stepping on each other's toes as everybody wants a piece of the action. So you see where I'm coming from?
Sure, and Senator, that's great. And we originally, when we started drafting this bill, I want to first say we did collaborate very closely with Maryland State Police on this bill. We originally started off with a statewide, and then that's when we curtailed back to say we will expand our jurisdiction to 2,000 feet beyond the buildings and then have the capability to do statewide as necessary. As we expand operations in jurisdictions across the state. Like I said, we already have buildings literally every corner of the state and leases every corner of the state anyway. But it's helping to clarify to be able to have law enforcement, our law enforcement officers have more liberty in sort of saying, and one of the things the Deputy Chief mentioned was having that fine line of what 1,000 feet is can be very challenging. If I was a defense attorney, I would point that out if someone came 1,200, 1,100 feet and there was.
Yeah, I have no problem with the 2,000 feet. That's fine.
Sure.
I'm concerned about this broader language. So last question. If we were to pass this bill, do you anticipate the need at some time in the future to add more staffing to the Maryland Capitol Police so that they can properly conduct this expanded function that you're envisioning?
So right now, great question, Senator. I think right now, while our primary focus is going to be state facilities and state grounds and state properties, we are currently right now looking to staff up right now in the process of expanding our current sworn law enforcement officers to help cover the major geographic areas which we currently are operating. And so our primary function is going to be traditionally in Baltimore and Annapolis, but we do have the jurisdiction to go in other sites as well. So I think we will be.
Many, maybe even most of our law enforcement agencies across the state have huge vacancies right now on their police forces and are desperately trying to hire more people and having a tough time filling recruitment classes. So I think what I hear you saying is you're going to be competing with them for people who are interested in getting into law enforcement, correct?
Well, Senator, all law enforcement agencies compete with one another. I mean, that's just the nature of it right now. I mean, you said it very well yourself, sir. Everyone's competing with each other. We're doing some very creative things, and when it comes to recruitment, but I think that is a challenge that is not just in Maryland. It's across the country. The shortage of law enforcement officers, the shortage of individuals wanting to go into law enforcement, as well as people retiring and leaving the field. So, regardless of anything, I think that's always a challenge that we are encountering. One thing it is important to note that many of our officers come to us as retirees or transferees, and we're looking at other opportunities to expand to have capabilities for a training program to put people through through a police academy. That would be new, something new we would be working on.
Thank you so much for answering my questions.
Sure.
Thank you. And sort of following up on Senator West, I heard you say that this 1,000 feet is challenging, I guess. But it looks like you're going to make it 2,000 feet hard stop. So I'm not so it seems to me that the hard stop of 1,000 or 2,000, it still has that issue of, well, here we are, we're stopping right here, and now the world gets a little fuzzier in how we enforce our own obligations and collaborate. So can you just briefly just explain that issue to me, because you have been mentioning 1,000 feet a couple of times.
Yeah, thank you, Senator. It's a great question. So we will be expanding from 1,000 to 2,000 feet. That will extend our full law enforcement capability to the 2,000 feet. And then the statewide jurisdiction allows us beyond that, if we do, to coordinate with local law enforcement entities to effectuate any type of criminal, parking, law enforcement actions beyond that 2,000 feet. It gives a flexibility where officers won't have to second guess themselves. If there's something happening, a mile down the road or something where they're seeing something happen, they won't have to second guess themselves or think twice about acting. They know they can go ahead and they have that jurisdiction to be able to effectuate that. And I mentioned criminal summons and arrest warrants, other things where a crime happens at a state facility, but we have to then call in favors and ask other law enforcement entities to serve a criminal summons or a criminal warrant or effectuate an arrest on our behalf, where we would be able to do that. So it would be taking some of the burden off of other law enforcement agencies that we are calling in favors for currently.
You're couching in terms of favors, but isn't there an obligation by all, the other law enforcement to work with you and do this on a routine basis and as an obligation, responsibility, and not as a favor or gift to you?
A great question, Senator. Yeah, in what way, maybe favor wasn't the right word, but what we are asking them to act on our behalf. A lot of times we mentioned that law enforcement agencies are very short-staffed, so their priority versus effectuating that criminal summons or arrest warrant might be on a different priority level than we have, so to speak. And there's, jurisdictional issues there as well, where in Baltimore City, Baltimore Police Department will ask us to respond because we're closer to a scene or closer to an incident, ask us to respond faster than they can potentially will.
And presumably your statewide status will allow you to
expand
be
beyond.
a more collaborative partner without the rigidity of.
Exactly right. In our reach, as we follow 5,000 people moving from State Center to the downtown area of Baltimore, part of that issue will be that collaboration where.
By the way, I'm not against the bill, but these questions are to test,
Sure.
to make sure we understand it. But my last, and you can follow up after the committee. I would appreciate hearing from other law enforcement entities, at least if they have no objection, or
Sure.
that would be helpful, or whatever they want to say. And then could you just give me a real world situation where the current law worked against you? And if you can say it briefly, that'd be great. If not, you can follow up. I just want to imagine where this is like frustrating and makes no sense.
Chief, you want to give some
Just very
examples?
quickly. Thank you, Mr. Chairman.
Thank you for your question. And just to clarify, the object of this bill is not to do what the state police does or try to go into, other areas. We have limited amount of people too, so that's not the object. But to answer your question, just this year with the swatting incident and the active shooter threat at the State House was an example of interdepartmental cooperation with state police and with FBI and with Anne Arundel County with other law enforcement agencies where we weren't able to follow up on many of the investigations because of jurisdictional issues.
So who did do that? That's what I'm just trying to, I'm not against this bill.
FBI actually did that.
But if you'd had this bill, would you been able to do it and the FBI would not have been needed? I'm not, or you both would have been doing it? I'm just trying to figure that out.
And there's been other instances where threats against elected officials that we have taken, and we have investigated that, and it has come up with, we found a subject in Queen Anne's County, and we went ahead and charged and got an arrest warrant for that person. We couldn't go in and effect the arrest of the warrant or summons because we don't have a jurisdiction there, so we would call local jurisdiction to effect that arrest for us. That's an example of some of the things that we would look to add to our jurisdiction and be able to do different things like that.
And Senator, just one thing that really frustrated me one time was just over the past year, we had one of our employees that we needed a welfare check done on, and it was a DGS employee still in the city of Annapolis. And one of the majors came to me and said, hey, we're going to do a welfare check. And I said, is that in our jurisdiction? And the answer was, well, actually, it's not. We have to call Annapolis Police Department and ask them to be primary law enforcement on site because it's outside of our jurisdiction. And then we had to call and wait for them to have the capability to be able to send an officer there, and then we would be the backup. But those type of things we would be able to respond to right away.
Well, those examples are very, very helpful. So,
Right.
and if you want to share more, that's great. Thank you, Mr. Chairman. Appreciate it.
Thank you very much, Senator James. Further questions from the committee? All right, seeing none, thank you all very much. Thank you, Senator. All right, with that, that'll conclude the hearing for Senate Bill 766. We'll now move on to Senator Quarterman with Senate Bill 782.
Thank you, Mr. Chairman, Vice Chair, members of the Judicial Proceedings Committee. Thank you for the opportunity to present Senate Bill 782, criminal procedure verdict of not criminally responsible, eligibility for evaluation for discharge. For the record, I'm Senator Paul Quarterman, District 2, representing Washington and Frederick counties. In June of 2022, the Washington County community suffered a tragic loss when Mark Allen Fry, Charles Edward Minnick, and Joshua Robert Wallace were gunned down and murdered at their workplace, Columbia Machine, by a disgruntled employee. The shooter fled the scene, only to be apprehended following a shootout at the Maryland State Police, where State Police Detective Sergeant Philip Martin was shot and wounded. Fast forward to April of 2023, the families of the 3 murder victims were informed that the killer would not receive any prison time for his crimes and said he was deemed not criminally responsible for his actions and as such committed to Clifton T. Perkins Psychiatric Hospital. Then just 2 months later, in June of 2023, again 2 months after he was committed to Perkins and 1 year after the horrific event, this individual was given the option to be evaluated for potential release back into our community. He did not contest this commitment at the time. However, he can be evaluated for release again each and every year. So this bill establishes that a committed person who is found not criminally responsible for murder in the first or second degree is not eligible for discharge from commitment for at least 10 years after the date the person was committed to the Maryland Department of Health. Colleagues, I would direct your attention to the physical note, as there was information that was pretty much verbatim of what MDH provided our office when inquiring over the interim. From 2019 to 2024, there were 24 patients discharged from Clifton T. Perkins with murder charges. Of those 24, 11 were transferred to one of MDH's other psychiatric facilities. The 13 who were discharged back to the community had an average length of stay at Perkins for approximately 9.9 years. So that's where we reached the 10-year mark. The families of the victims deserve better. It is agonizing for them to now be victimized and relive this horrific experience on an annual basis, knowing that the individual who murdered their loved ones could be released in as little as a year after undergoing therapeutic services and or the next year. Colleagues, if the way this bill is structured presents challenges, by all means, we are open to working with the committee to strike the necessary balance. We understand this is a difficult situation. However, it is wrong for someone to commit multiple murders and then have the possibility to be returned to society just as little as a year or two later, and again, continue to victimize the families over and over again. We thank you for consideration, and we respectfully ask for a favorable report on Senate Bill 782. So, let's rock.
My husband, Mark Fry, and 2 of his co-workers were murdered at Columbia Machine on June 9th of 2022. A 4th wounded man escaped and a police officer was shot as well. The killer who stalked, planned, and carried out this heinous slaughter has been coddled by the state of Maryland. He was not prosecuted or sentenced. It was a doctor who decided that he was not responsible for his actions during the split second that he fired more than 30 rounds into 4 unarmed men. He was placed in a hospital and just 20 days later was eligible for release. No jury has heard this case and no justice has been served. Last year, I testified on Senate Bill 554 regarding the not criminally responsible. I was confident that by bringing the antiquated laws to your attention that you would act and do the right thing. I was terribly mistaken. You failed us. You are aware of how your laws affect murder victims, yet you chose not to make any change. Allowing a murderer the right to request release once a year is absurd. Victims never get justice, closure, or any peace of mind. Every day there's a chance that I'll get that next notice that Killer Joe is eligible to be released again. Any bit of healing is gone, and I'm taken right back to June 9th. Under the United States Constitution, Mark, CJ, and Josh were entitled to life, liberty, and the pursuit of happiness. An unprovoked killer took those rights away, and in return, Maryland protects the killer and victimizes us, the families. Anyone who takes a life is evil, and they need to be kept where they can't hurt anyone else. You are delusional if you think you can fix them. Of course, they're crazy. Sane people don't kill their coworkers. You must update Maryland law. You must use common sense. Your constituents are not safe. Your families are not safe. You owe this to the people who voted you to the seats at this table to keep us safe. Do the right thing today and vote in favor of Senate Bill 782. Thank you, and please refer to my written testimony that's been uploaded.
Thank you so much. I know it's not easy to come and share your story, so thank you for doing that. Senator Sidnor has a question.
Thank you very much. For the sponsor, I see that you're copied on the judiciary's testimony. Could you speak to that?
I saw the judiciary's testimony, understanding there are some challenges there. So I said I would defer to your judgment, my friend. And I don't know how to strike this balance.
Neither do I.
I know.
It says it's unconstitutional.
That's the challenge here, right?
Huge challenge.
Because understanding that aspect of it, the due process, at the same time, I would think most reasonable people would think that someone who murders not just one, but multiple individuals, understanding on the pretense of being treatment, there should not be the ability for that individual to be released in as little as 2 months. The individual was committed to Perkins. 2 months later, he requested evaluation for release. That doesn't make sense. And so I don't know the answer. Again, that's why we come to you of how to strike that balance. Because yes, I mean, to your point, I did see the issue there. And so then lies the challenge. And I don't know what it is, because I know that we believe, again, to the fact of when you murder somebody,
And
sane or insane,
I understand.
we cannot have the option to come back in society. Look, we want people to be treated. We hope for rehabilitation, someone can get better. But 2 months, a year, I don't see how that's even practically feasible, so.
Thank you.
Oh, thank you. I'm glad you brought this bill, and I'm glad you came back, because my just feeling is that we do a lot, and understandably, with people in these defendants, and a lot with people that are in prisons, but it seems lost in all of this are victims. And whether you're still alive and suffering from the harm that was caused by a defendant, or in your case, a lifetime of loss that can never, be rectified in any way. And I thank you so much for this. I have lost a family member, so it's a terrible, terrible pain. I do, maybe you, Senator, can help me. I thought that if you were, put in a mental institution and determined not to be, in your right mind, basically, that what would happen is that, you would be reevaluated. If you're ever determined to be, rehabilitated or improved, there would be a determination before you be released that you could stand trial. But I guess what you're saying is the law is, if the court determines at the moment of the crime, regardless of what happens later, you were not responsible, then nothing subsequently would change that situation. And if you got better, you could be released, but you'd never be held to account because of your mental condition at the time of the crime. Is that correct?
That's my understanding, correct. I mean, I would defer to the legal minds in this room, but yes, if you were found not criminally responsible, that's for that act. You can't then be charged for that act because you were found not criminally responsible for
And
that
your
act.
understanding is that currently, I don't know if you get a chance to look at what other states do, but you are very right to identify this as a huge problem and gap, because especially in these crimes of murder and the like. So did you look at any other states that might have a different approach than we do in terms of trying to hold people to some account, or at least not let them back out? Did you find
I'm not familiar what other states may do. Our focus has been just mostly here in Maryland and in the Maryland Department of Health. But again, I think back to your point, I think you make an excellent point. That's a lot of this, whole point of this is the re-victimization of families. Because
yes,
every
I'm
year,
very
Ms.
worried
Fry
about
gets a letter in the mail and has to relive this horrific experience. Not only that, but she's obviously living it every day. But it's just continuing to be brought back in front of them, and not knowing any given time, this could just happen,
I cannot, it's enough for me to deal with the death. I don't know what I would do if every year I had to contend with
Thank you,
that
Senator.
aspect of it. That's just too much. So, I guess I'll stop there, and I'll try to do some research myself. There's got to be some kind of solution here, and maybe we have to put a group together to figure it out. Maybe we can't pass a bill at this moment, but I thank you very much, and thank you as well for coming down.
Thank you, Senator.
Thank you.
Thank you so much. Any other questions for the sponsor All right, seeing no questions, thank you again for being here. We really appreciate
Thank you,
it,
Vice Chair.
both of you. That concludes the hearing for Senate Bill 782. I saw Senator Zucker arrive. Senator Zucker, come on up, please, and bring your panel. We're going to begin Senate Bill 765.
Well, good to see you, Mr. Vice Chair, distinguished members of the Judicial Proceedings Committee. Mr. Vice Chair, I'd like to say I just filed this bill to see you guys. That's half of it, but here to, in support of Senate Bill 765. And colleagues, I wish I could say that I came up with the idea of this bill. I didn't. It was actually Delegate Mike Griffith, who is a delegate in the House. He spoke recently about he was a foster youth, and basically what this bill does, Mr. Chairman, is foster youth are our kids. They're wards of the state. They're our children. And right now, the situation is sometimes they have to choose whether or not they want to stay at a foster home or go to higher ed, because what's happening is when they stay at a home, if they go away to school, there's a limit on bed capacity. So often the foster home has to give up the bed, even though the foster youth will be coming back to the house. It provides, unfortunately, a situation where they don't have a home to go to, or if they do have a home to go to, it's another foster youth home. I do want to just, thank the co-sponsors, Senator Gallion, Senator Smith, Senator Waldstreicher, Senator Folden, but we are working very closely with Department of Human Services. Actually, I think a lot of, they just promulgated regs, and a lot of that was based on what we were doing around this legislation. Mr. Vice Chairman, we will be putting in a technical amendment that clarifies our intent, but also coincide what DHS wanted, and we're all on the same page with that. But, you know, I view this bill as something that's needed in order to make sure that foster youth aren't picking between whether they're going to go to higher ed or whether they're going to stay in their foster care facility. With that, Mr. Vice Chair, I'm happy to answer any questions and turn it over to my amazing panel.
Thanks. Let's take the panel and then do questions.
Absolutely fantastic.
Good afternoon, Chair Smith, Vice Chair, and committee members. My name is Steve Vicerno, and I'm the Director of Family and Children's Supports at the ARC Northern Chesapeake region. I'm here today to advocate on behalf of college students in the foster care system and ask for your support. To illustrate the value of Senate Bill 765, I'd like to share the story of just one of the youth that our program had the privilege to serve over the years. This youth, like so many others in the system, suffered abuse and neglect, witnessed family violence, separation from siblings, battled through severe anxiety and depression, and many other hardships. Despite all this adversity, this youth still had the ambition, desire, and determination to seek out higher education. This youth had the mental fortitude to hope and to dream. This youth, standing on the threshold between adolescence and adulthood, dared to visualize a path to success and attempt to end the cycle of loss and heartache. But there was a roadblock to this path. Regulation that is currently in place all but forces a choice between maintaining a connection to home and family or education and community. If they choose higher education, they essentially forfeit the certainty of a loving and caring home. They can live on campus, but when campuses are closed, will suffer again from housing instability. If they choose to remain in their foster placement, they forego the chance to form a new sense of community, this time on a college campus. By supporting this bill, this committee will help ensure that every college student who's in the foster care system has a home base, a foundation of support, love, and nurturing that will sustain them during their college experience. Thank you.
Good afternoon, Mr. Chair and members of the committee. For the record, my name is Teresa Hessler, and I am here today representing the Maryland Association of Resources for Family and Youth, also known as MARFI, in strong support of Senate Bill 765. MARFI members are organizations that provide foster care, group homes, and critical services to Maryland's most vulnerable youth, those placed out of their homes due to abuse, neglect, severe mental health and medical needs. Our programs across the state support youth who have faced unimaginable challenges, and we are committed to ensuring they have every opportunity to thrive. This bill is certainly a step in the right direction. It recognizes that young people who leave their foster placement to pursue higher education should never have to choose between their academic goals and having a safe, welcoming place to return to when campuses close for scheduled breaks or temporary absences. Many of these young adults have no permanent family to return home to, making it critical that the out-of-home placements they left behind remain available to them. By providing an exemption placement limitations for these students, Senate Bill 765 helps to ensure they can focus on their education without the added burden of housing insecurity. Stability is the foundation for success, and this bill acknowledges that. For many young people in foster care, their group home or foster placement is more than just a residence. It is their support system and home base. We ask this committee support Senate Bill 765 with the confidence for our youth, knowing they have a home to return to, a place that wants them, welcomes them, and supports them. Thank you for your time and consideration.
Thank you so much. Questions for the sponsor or this panel? All right, that's an easy one. Seeing no questions, thank you, Senator Zucker. That concludes the hearing for Senate Bill 765. I see that Senator Heddleman has joined us. Senator Heddleman, if you want to come up and bring your panel for Senate Bill 669.
Good afternoon. I was looking for the rest of my panel, who does not seem to be here. Oh, Jane, good to see you. Okay. Okay. Good afternoon. I'm Shelley Heddleman, Senator from District 11, and I am very happy to be here today to testify on Senate Bill 669. So many of you may remember back in 2018, actually, it was before that. In 2019, I was over in the House with many of you, and we created a rape kit testing grant program. Part of the reason for that program is I had had conversations with local law enforcement and state law enforcement who had expressed frustration in not being able to have enough resources to be able to address some of the backlogs that we had in testing our rape kits. I've come before this committee a number of times on a variety of different issues having to do with rape kit testing, and we have made great deal of progress on this issue. This grant fund, what we're doing here is expanding what it is able to do. One of the reasons for that is we have been the beneficiary of federal money, the Sexual Assault Kit Initiative funding from the Department of Justice that has enabled us to test a lot of our historic kits. And we are in the second tranche of that funding. We got 2 big grants, and we need to spend that money by the end of September. In order to do that, we are kind of front-loading, sending our kits to the lab to be tested. Along with that, we have had federal funding to support MCASA in their role to notify victims and to provide them with support services. These are people whose kits may be a number of years old, and they're getting a phone call to say, your kit is going to be tested. And as you can imagine, that may be surprising to a number of people and raise a whole lot of issues. So we want to make sure that they have the support and with trained individuals who can help them through that process. In addition, the funding goes to support investigators who are in the Office of the Attorney General, who then, when we get the information back from the lab, can go and investigate, track down these cold cases. Because we are kind of front-loading this funding to ensure that we're using it, in terms of testing, we want to expand the use of this fund to make sure that we have funds available to do those other two services I just described, to make sure that the individual victims are getting the support they need, and to make sure that we're funding investigators to be able to go and investigate those cases. So that's what this does. It does so. It also allows the funding to be used for telehealth, something that we passed last year, which expanded how people can get forensic exams done. This is very important to do, especially this year, because we have the potential to not be able to get additional federal funding, and we want to ensure that we have the state funds to be able to protect people who have been through this terrible crime and who deserve justice, and we need to expand this use. So without further ado, I will turn it over to my two witnesses who can further make the case. Happy to answer any questions. Thank you.
Good afternoon, Mr. Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of Senate Bill 669. Senator Hedelman, thank you for your continued leadership on this issue. We very much appreciate you. As you've heard, this bill does two things. It allows this funding, which is in the state special fund, and there is funding there that has not been expended from prior years. So this is not kind of new funding. We have this money available. It's going to allow it to be used for peer-to-peer telesafe, which will expand access to the exams. And I really think of it as a backup plan to finish the job that Maryland has started, to test and investigate and notify victims about the rape kit backlog. There were over 6,000 untested rape kits, 6,000. Since that inventory, we've found more, we've tested some, but there are still thousands. And the federal funding, that's not a guarantee that we will get more federal funding to complete this job. But be clear about what Senate Bill 669 says. It says if we don't get more federal funding, if there is still a backlog, and if the state of Maryland has money in this fund, then the state must use money to continue the backlog project, to continue testing, to continue support for victims, continue investigators at the Office of the Attorney General to assist with investigations. And again, all three of those are currently supported with the federal money, and the state money would be used only if we get this. One of the things that I want to emphasize that Senator Hedelman already said is that we are kind of front-loading the process now in our effort to expend the federal money, because if we don't expend it, we know we won't get more. But what that means is that we're going to have kits that have been tested but not investigated. If we don't do this with the state money, if we don't have a plan to continue the funding, we're going to trade our untested backlog for a backlog of tested kits that aren't investigated.
Thank you, Ms.
And
Jordan.
that's not justice. So for those reasons, we ask for support for Senate Bill 669.
Today. Ms. Krinky?
Good afternoon, Chair Wellstreicher, members of the committee. My name is Jane Krinky. I'm here on behalf of the Maryland Hospital Association in strong support for Senate Bill 669. As this committee knows, there are hospital-based sexual assault forensic exam programs across the state where specially trained registered nurses care for survivors of violence, abuse, and neglect. Many of these SAFE programs rely on grant funding to support their staffing and infrastructure costs. And as a result, that can impact how they their 24/7 coverage, especially in rural and less populated areas. As you've heard from Senator Hedelman and Ms. Jordan, this expanding the grant fund to include peer-to-peer telehealth support could help expand access and support those nurses we have working across the state. We think telesafe services can be helpful during case consultation and exam support, as well as assisting in training and simulation. We think it could really help support this workforce across the state. Like I said, many hospitals rely on grant and federal state funding. So expanding this, as you heard, as a backup in case we don't get access to those federal funds is really critical for ensuring these programs can continue to operate. So we ask for a favorable report on this bill. Thank you.
Thank you so much. Questions? Senator West.
Thank you, Mr. Chair. I guess this question is for the sponsor. In the years I've been here, this issue of rape kit testing has come before us on various occasions. I've always supported it. And I see in the fiscal note, we set up this fund back in 2019. And it currently seems to have $4 million or thereabouts in the fund. So what has delayed using the money to test the rape kits? Why haven't these rape kits been tested?
So that's a complicated question. So some of that funding has been used, and it's been used to help our internal labs expand their ability to test. It's been used to buy equipment. It's been used to do other kinds of things. The money that we have now from the federal government is also being used for testing through these two tranches of the SAKI grant. So we are testing many, over 800 some kits have been tested. Unfortunately, we have to outsource a number of them to a lab out of state, and that is ongoing. And that's happening, and it has been happening for many years. We have a lot of them, so we're making our way through them, and unfortunately, this crime is not stopped, so we have to continue the work with the rapes that are happening every day. So it is kind of a perpetual issue. We are making some headway. It is very labor-intensive, expensive work, and so we're plugging away.
Well, at the rate we're going, how long is it going to take to complete this job? If we started in 2019, it's now 2025. Is this just a case of government being inefficient, as government so frequently is?
It's
and we give them the money and they're not able to do with the money what we expect them to do?
Well, actually, the money that we are using to do most of the testing is going to a private lab out of state for a variety of reasons, because we don't have all of the internal state capacity, lab capacity to do all the testing that we need to do. So we do outsource it to a lab in Virginia. In some cases, local law enforcement sends them to a lab in Florida. I know in our county, they have contracts with both of those labs to address the slides from GBMC, as well as the backlog that we have. So it's complicated, and it is labor intensive, and it takes a while, but I don't think and there are other crimes that they need the labs for, right? So our police labs are doing, I think, the best they can with the resources they have. They're investigating murders and thefts and all the things that they do, in addition to trying to look back and address this backlog.
Well, then answer me this. At the rate we're going, when do we expect to finish the job of completing testing these rape kits that we had all the way back in 2019? How many more years is this going to take?
So I'm going to actually let somebody from the Attorney General's office, who in another panel might be able to answer that better than I can. I don't know the answer to that question.
I don't often say I'm seething with frustration, but I really am seething with frustration.
I share it.
Because we have addressed this year after year.
Yeah, I share that it's frustrating we do have some resources available now, and we are using them.
$4 million. Why don't we use the money to get the rape tests?
Well, we actually don't have access to the entire $4 million. In order, we have it in the budget. The fund was set up so that it could be carried over year to year. But it needs to be part of the governor's budget. And there's $3.5 million that's in the budget this year to be able to do that. And that will be going forward.
On top of the $4 million that's in the fund right now, we're going to add.
No, not on top. So there's something in the supplemental that may address that. So bottom line, it's at least 3.5. It might be more than that.
Okay, thank you.
Senator Love.
Thank you, Mr. Chair. Thank you for bringing this bill, Senator Hedelman. And I don't know if this question is for you or for someone else on your panel, but just to help us get a better understanding of this bill, do you have any examples of survivors this might have helped?
Well, I mean, yeah, let me let the group that has the most contact with survivors answer that.
Thank you, Senator Love. I do. Let me tell you about a woman I'll call Emily. So Emily was raped more than 10 years ago. She did everything that we tell people to do. She went to the hospital, she called the police, she reported the crime, she was willing to prosecute, and nothing happened. So years later, because of this project, she has this entire time been living in absolute fear because she's believing that her rapist is out there. And we finally, the state just didn't bother to test the kit. They finally tested the kit, and they found that it was a serial rapist. And the serial rapist was already convicted, was already in jail, and she could have been living in peace for all of these years. And not only did the project make sure that we tested the evidence that gave us this information, but it's important to know that we also had to advocate with the police for them to reach out and tell her what had happened, because they weren't going to. From their point of view, the whole thing was closed. It was over. They didn't have any concern about this. And that's why this project really, it's a little more complicated than just sending in a kit and having it tested. That's important. But there is support that has to happen for survivors. Senator West, I share your horror and frustration. By my quick math on my calculator, it looks like it would be about 7 years if we continued at the pace we're going. There's 7 additional years. There's no reason that we should go this slow. We can continue to press on. And I will say in the past, I think, say 8 months or so, there has been a renewed effort by the government partners involved. They're meeting weekly. They are really pressing to get the funds. They were unable to expend all of the federal funds. We don't want that to happen again. The state of Maryland needs to take this seriously and think of women like Emily.
Thank you.
If I could just follow up with one other circumstance, Senator Love. So in 2023, Baltimore County Police arrested James Shipe, and he is behind bars right now and accused of raping at least 5 women between 1978 and 1986 in Baltimore County. And that is because of the testing that we have done with these slides from GBMC. So things are happening. It's slow and painstaking, but it is really important to hold people accountable. Thank you.
All right, seeing no questions for this panel, thank you so much. We'll move on to favorable with amendment. Andrea Mansfield, Carissa Hatfield.
Good afternoon, Mr. Vice Chair and members of the committee. My name is Carissa Hatfield, and I'm counsel to the Sexual Assault Evidence Kit Policy and Funding Committee. I'm also privileged to be here in my capacity as co-supervisor of the Sexual Assault Kit Initiative Cold Case Investigation Team at the Office of the Attorney General. And on behalf of the committee and my team, I'm here in support of SB 669 with the sponsor amendments. So the Cold Case Investigation Team was created in 2023 under this grant that Senator Hedelman mentioned, after law enforcement agencies indicated to us that they really wanted to investigate these cases, but they simply did not have the time or the resources to be able to dedicate to it. So that's where our team now comes in. The team has a simple mission to establish trust with local law enforcement agencies and assist them with every step of investigating their sexual assault cold cases. It includes hours of case review to determine cases that are eligible under the statute, working with these agencies to fill out all of the required paperwork to submit the cases for testing, and when they return from testing, to work with that law enforcement agency to determine how they would like to proceed in terms of investigative support, whether they would like us to take the case on fully as our case, if they'd like us to work in tandem with them, or if they would like to investigate the case on their own now that they have the test results back. As of February 28th, the team has met with 24 law enforcement agencies, has picked up 436 cases for review and preparation for testing. This doesn't include the 267 cases that are currently pending from 3 law enforcement agencies, and 95 cases where testing has already occurred in Prince George's County, and we are providing investigative support. The team, as you can imagine, their work is essential and even 20% of the cases that they have in their possession right now are returned with a CODIS hit. That will leave each of our 2 investigators with just over 80 cases each, which is far beyond what they can handle. This fund will assist us greatly, and that's why we would ask for a favorable report with the sponsor amendments on this bill.
Thank you so much. Ms. Mansfield.
Thank you, Mr. Vice Chair, members of the committee. Andrea Mansfield, representing the police chiefs and the sheriffs. I'm here supporting this bill with amendments. And I really want to thank the sponsor as well as the advocates that have been here, because we've been having conversations on this bill for the past probably 2 months or so. I'm trying to work out some of the issues that have been involved, and really want to thank their willingness to accept an amendment. As introduced, there is language on one page that brackets out law enforcement's ability to use the funding through this grant for equipment, for the outsourcing, as was described earlier, to ensure these kits can be tested in out-of-state labs. That language will be staying in the bill. There's also an amendment to extend the time frame in which the grants can be used. One of the challenges law enforcement or the forensic labs have been having in terms of procuring, since it's a grant and they are putting in for reimbursements, just the timing of when they are purchasing equipment or maybe the outsourcing, but the timing isn't lining up well with the 1-year grant. So this would allow the grant be used for 36 months to help with that and hopefully make it more efficient for them to use the dollars. Where we are still having conversations, as I know, law enforcement, because when this fund was created, the original intent was to be used for law enforcement agencies and in state labs for doing these testing. By adding in the additional uses, which law enforcement, the chiefs and sheriffs are not concerned about that at all. They agree, they think that is a good use of the fund, but it just will kind of shift the funding and the dollars that will now be able to be used by those law enforcement agency, the forensic labs located there. So the amendments that are included in the statement would be, one, to continue to give priority to the law enforcement agency, forensic labs, or at the very least hold those labs harmless so they can continue to receive the same amount of funding in the prior fiscal year to do that testing as well. And we're still having conversations on that language. But that we support with favorable with amendments. Thank you.
Thank you so much. Questions for this panel? All right, seeing no questions, thank you, Senator Hedelman. Thank you, everyone. That concludes the hearing for Senate Bill 669. Senator Watson is up. Next was Senate Bill 820. And feel free to bring up your panel, please.
Let's see, do I have a panel? Does anybody want to come stand with me? Hello, good to see you. Good afternoon, Vice Chair Waldstreicher, colleagues. For the record, I'm Senator Ron Watson, representing the 23rd District, Prince George's County, and I'm pleased to present Senate Bill 820. This legislation will improve neighborhoods by empowering municipalities to increase the maximum fine they may impose for a municipal infraction from the current $1,000 to $5,000. This action mirrors last year's General Assembly action that authorized charter counties to increase fines from $1,000 to $5,000. That was Senate Bill 522. Municipalities need the same authority to impose higher fees for serious municipal code violations that counties have. In your packet, you'll find a couple instances of where the $1,000 did not change behavior whatsoever on incidents occurring in Prince George's County. The $1,000 cap was enacted more than 30 years ago. This amount has clearly been outstripped by inflation and has lost its efficacy. The amount no longer serves an incentive to correct violations or as an appropriate penalty for the public harm due to the violation. The current maximum fine of $1,000 can be perceived as a mere operating cost, or as some of these owners say, it's just the cost of doing business. By raising the fines, this bill will restore the deterrent effect and encourage owners to maintain their property. In addition, the cost of code officers investigating and prosecuting a violation is itself well over $1,000, in that our code officers must inspect and re-inspect numerous times, attend court hearings to meet contractors, and arrange abatement. Most of our residential property owners are deeply invested in the well-being and quality of life in their neighborhoods. Municipal residents should be afforded the same opportunity to live in violation-free neighborhoods that charter county residents do.
On behalf of the residents of the great municipalities of the state of Maryland, I urge a favorable report of Senate Bill 820, and I'd like to turn it over to my panelists. Go ahead.
Good afternoon, Angelica Bailey-Thupari for the Maryland Municipal League. Thank you in advance for your time. We also want to thank the sponsor for bringing forward this fantastic bill, who used one of my favorite phrases, which is empowering municipalities. That's exactly what this bill will do. It is permissive. It is not mandatory. Obviously, it could help our bottom line, but it can also dissuade bad actors, which the current fine levels are not sufficient in doing. So we do ask for a favorable report. And again, thank you to the sponsor. Thank you.
Good afternoon. My name is Bill Gardner. I'm the Assistant City Manager for the City of College Park. I've been in College Park for about 11 years, and before that, I was mayor for the City of Hyattsville for 8 years. And I'm also here to ask that you support SB 820 for the reasons that have been raised by the sponsor and by the MML representative. First, I want to say that most municipalities that I've been aware of work very closely with property owners to try to get compliance voluntarily prior to infractions being issued and prior to fines. And so this increase wouldn't impact most of our property owners who have a violation. They just get fixed generally without imposing a fine. But unfortunately, as the sponsor noted, we have a number of property owners who see this as a cost of doing business. They will have construction done on their properties without permits. They will have tenants living in units that don't meet code, haven't had the lead inspections and things like that. Serious life-endangering violations. And raising the allowable fine from $1,000 to $5,000 hopefully will get their attention soon and will help urge them to come into compliance prior to going through a lengthy and expensive court system. And of course, judges can also amend the amount of fine that the municipality has imposed. So for those reasons, I ask that you all support this bill. Thank you.
Mr. Chairman, I'm Paul Ellington. I'm here on behalf of Chrisfield, Salisbury, and Cambridge. And I also used to be a Bowie City Councilman, so I know what the sponsor, the senator, speaks. We have a lot of problems with absentee owners and corporate owners that really never even come to town. But this bill would give us a little bit more of a hammer to get beyond just the cost of doing business, as the senator indicated, and it will get the attention of all violators, and we believe it will also bring some of the absentee violators in compliance. So I would ask a favorable report. Thank you.
Thank you. We're going to switch to virtual in a second here, but any questions for the sponsor or this panel? All right, seeing no questions, thank you. So, Senator Sinor.
I wanted to give you all an opportunity, since you were up, or even the bill's sponsor. It looks as of the record, there is just one piece of testimony that's unfavorable from MMHA. Have you seen it, Senator? You wanted to go up there.
Thank you, Senator. I did see that, and you can't please everybody.
That's your response?
That's my response.
Thank you very much.
Further questions from the committee? All right, so it looks like, do we have someone joining us virtually? Is anyone in the room? Sorry? Ms. Jordan, if you can hear us. Oh, Emmett Jordan. Emmett, what's going on? Hey, what's going on? How are you?
Hey, good
Welcome.
afternoon.
Hey, good to see you.
Yeah, great to see you. Thank you so much. Let me just say that members of the Judiciary Proceeding Committee, I'm Emmett Jordan, Mayor of the City of Greenbelt, speaking in support of Senate Bill. I'm doing pretty well. Can you hear me now? Yeah, great to see you.
Yes, we can hear you. We can hear you.
Okay. So speaking in support of Senate Bill 820, which proposes to increase the maximum allowable fine for municipal ordinance violations from $1,000 to $5,000, we're grateful to Senators Watson and Rosapep for introducing the legislation. For Greenbelt, this bill will enhance our ability to enforce local ordinances and maintain our community's quality of life. The current $1,000 max it's become inadequate, especially for serious violations and repeat offenders. We need more flexibility to motivate property owners to quickly resolve problems. Let me share a recent example. We had a 100-unit development with repeated water leaks and code violations, and the $1,000 cap was just too low to really motivate the owners to swiftly address these issues. So SB 820, it's enabling legislation, so it allows us the discretion to set up appropriate fines. In Greenbelt, we try and collaborate with property owners, and we only levy fines and escalate fines when necessary. Our preference is really to work with property owners, but this flexibility really allows us the crucial ability to tailor our enforcement needs and to really focus on the worst violations. So, on behalf of the City of Greenbelt, we appreciate this legislation and we ask for a favorable reading from the Judiciary Proceeding Committee. Thank you very much.
Thank you, Mr. Mayor. And we'll now switch over to Mayor Benitez, and then we'll continue on and then we'll open it up to the committee for questions.
So, good afternoon. Can you guys hear me?
We can. Welcome.
Thank you. So, good afternoon, Chairman Smith, Vice Chair, and the esteemed Judicial Proceeding Committee. I'm here on behalf of the City of Mount Rainier. I'm expressing our strong support for SB 820. You have heard from our various colleagues that are over there currently in Annapolis why we need it. For the City of Mount Rainier, we stand in solidarity as well. The violation, so moving it from $1,000 to $5,000 will allow local governments to enforce their laws more effectively. Many municipalities, including Mount Rainier, struggle to address persistent violations due to outdated penalties limits that fail to serve as meaningful deterrents. Increasing the maximum fine will enhance our ability to protect public health, safety, and overall quality of life by ensuring compliance with zoning, land use, and public nuisances. So on behalf of the City of Mount Rainier, we ask for favorable support for Senate Bill 820. Thank you so much.
Excellent. Thank you very much. All right, Charles, you're up. Welcome.
Good afternoon. Can you all hear me?
We can, yes.
Good afternoon. Thank you very much for taking my testimony virtually today. Thank you, Chair Smith, Vice Chair Waldstreicher, and esteemed members of the Judicial Proceedings Committee. My name is Charles Colbert. I'm here today on behalf of the town of Upper Marlboro in strong support of Senate Bill 820. This legislation is critical for municipalities like ours as it increases the maximum fines for ordinance and resolution violations. As many of the previous panelists have mentioned, right now the current cap of $1,000 is simply not enough to deter bad actors, particularly repeat offenders and irresponsible property managers who neglect their obligations to our communities. By raising the maximum fine to $5,000 for municipal infractions and misdemeanors, this bill gives local governments a much-needed tool to enforce the rules that protect our residents' quality of life. Stronger enforcement means safer neighborhoods, well-maintained properties, and a more attractive environment for businesses to grow. In Upper Marlboro, our local ordinances play a vital role in preserving public health, safety, and environmental standards, but enforcement is only as strong as the penalties behind it. And this bill will allow us to take meaningful action against those who disregard our regulations and ensure that our community continues to thrive. We sincerely appreciate Senators Watson and Rosapep for sponsoring this legislation, and I respectfully urge the committee to support its swift passage. Thank you again all for your time and consideration, and I'm happy to answer any questions.
Excellent. Thank you very much. Senator Charles has a question.
Thank you, Mr. Chair. This is for Senator Watson. In terms of, for this particular, the $5,000 fines, what is this specifically for? Is it dumping? Is it a combination of dumping?
It's code enforcement. So you got to remember, last year we passed the identical bill at the county level. And the conversation is, you've given the counties the tool to enforce their codes and ordinances, but you haven't given the municipalities the same rights and privileges to be able to do the same. You know, my wife represents the city of Greenbelt. There have been some significant things that have occurred there by the apartment owners, and we just didn't have the teeth to really go after them because they're getting so much money. $1,000 is a drop in the bucket. This allows us to level the playing field and gives those leaders, you know, of the municipalities the ability to enforce and to improve the quality of life for their residents, as they are now able to do to a better extent in the county.
Okay, so I know in the county, if you dump and litter and all of those things, you know, that's one of my major pet peeves. And
so dumping litter is a little different than what we're talking about here. And maybe our municipal leaders can explain it a little bit, unless you catch that person. This is a little different. I'm talking about landowners here. I'm talking about those who own the apartments, those who take advantage of the multiple residents they have because they're bringing so much money in, and take their time in fixing leaks and plumbing issues and those types of things. That's what this is intended to get at.
Okay. Thank you, Senator.
Thank you.
All right. Seeing no further questions, thank you all very much. Thank you, Senator.
And just so you know, we have palm trees in Prince George's County.
Gorgeous Prince George's. There you go. All right.
Thank you.
Thank you very much. All right. With that, that'll conclude the hearing for Senate Bill 820. We'll now move on to Senate Bill 711, and then we're going to jump down to Senate Bill 828. So, Senator McKay, you're up.
Well, Mr. Chairman, Mr. Vice Chair, members of the committee, I have to inform you that William Shakespeare, who lived from 1564 to 1616, did not mention off-highway vehicle trails. But in an Shakespearean style, I will try to quote, "The venture forth where no smooth road doth lie, over rock and root, 'neath boundless open sky. No path is marked, yet onward must we ride, for fortune favors those who dare the stride." Now, Senate Bill, what is this number? 711 is a reintroduction of the legislation we sponsored last year in this committee, which it was passed, creating an oversight board for the OHV Title Tax Fund. Now, this creation is an oversight board, as written, is common with DNR funds designated to specific purposes. The OHV Title Tax Fund is a main funding mechanism for OHV trail creation and maintenance, and is solely funded through the sales of off-highway vehicles. The sales of them. As such, the OHV users should have a seat at the table with DNR to ensure that voices are heard. This is a way that those who title tax fund have input on how the funding is spent to ensure how they're getting the kind of access they desire. The legislation also expands the funds to help the general park maintenance, and currently the funds cannot be used to create, can only be used to create and maintain trails, as the legislation allows DNR to build out campgrounds, parking lots, and other amenities for specified funding limits. This will allow the users to be almost entirely self-funded on their own access, and at the same time relieving some of the burdens the DNR General Fund is in building out these facilities. Now, the department has submitted support with amendments letter. We support those amendments and look forward to passage of Senate Bill 711. Entertain any questions at this time.
Excellent. Oh, I think you have one witness signed up in favor. Is Stephen Linsmeyer? Yeah.
He is.
Welcome.
Good afternoon. Thanks for the opportunity to present testimony in support of Bill 711. I don't quote Shakespeare, but I'll try and do my best. My name is Steve Linsenmeyer, the board president and a founding member of the Maryland Off-Road Vehicle Alliance. We're a 501c3 formed in 2013 to advocate for sustainable public and private OHV and multi-use outdoor recreation areas. We've been stakeholders in St. John's Rock and Wolf Den Run OHV parks from the inception and have invested thousands of hours in those projects and participated with DNR, and they've been successful. Along with other members of the Alliance, I've worked with DNR leadership, the Forest and Park Service, local, county, and state elected officials, their communities, landowners, the Maryland OHV dealers, as well as clubs and associations throughout the state that represent well over 15,000 individuals and their families who support this bill. At the risk of repeating some of the Senator Kay's comments, in 2018, the Title Tax Fund was established to provide the needed resources for DNR to specifically establish, operate, and maintain current and future OHV outdoor recreation areas. It's important to note that this fund is completely self-funded by the OHV users through the title tax, and to my knowledge, the only user group in the state to do so. The fund has been critical to the success of both Wolf Den Run State Park and St. John's Rock, which are currently the only two OHV facilities in Maryland. This bill, 711, establishes a standard advisory board representing the OHV community who will collaborate with DNR and its implementation of resources that the fund provides. It should be noted that since Wolf Den Run State Park opened, there have been well over 10,000 multi-use visitors. It is experiencing year-over-year growth, and not just for motorized recreation, but hiking, biking, hunting, and birdwatching. And it's estimated that these two facilities are adding approximately $2.5 million annually to Maryland's economy, and we're confident that this bill provides the tools to increase that amount significantly. In closing, I would like to mention that it's our understanding that the Department of Natural Resources supports the legislation, and we look forward to continuing our strong relationship with them. And on behalf of the Maryland OHV Alliance and those we represent, we appreciate the opportunity to present support for the bill and look forward to a favorable report.
Thank you very much. All right. Questions from the committee? All right, with that, that'll end the hearing for Senate Bill 711. Actually, we get to go to Senator Henson. Are you ready to go? We have to hop in with you real quick, sorry. Senator Henson, we're going to go with Senate Bill 721, and then we'll jump down to Senate Bill 828.
May I bring up my panel? Thank you. I believe we have joining us Lisa Jordan from Maryland Coalition Against Sexual Assault. We did have signed up Erin Perrell from the Frederick County Sheriff's Office, but she indicated she would not be able to be here. You are here. Lovely. Thank you. Wonderful. Thank you. Thank you. For the record, colleagues, Senator Shanika Henson, Legislative District 30, here to present Senate Bill 721, Family Law Protective Orders Consent. I know you hear this a lot, but this truly is a simple bill. We currently have the opportunity for permanent protective orders when the petitioner meets those requirements. What this bill would do is allow those permanent protective orders to be entered into by consent. Right now, they can only be had predicated on the finding of abuse and meeting those criterias. But what our state's attorneys have told us is that this can be a useful bargaining chip when you're trying to ultimately get relief from domestic violence or violence that's eligible under the bill, but you don't want to have to go through a full evidentiary hearing where that survivor is required to relive those accounts of abuse, to put that evidence on the record. This would allow these orders to be had by consent. With that, I will turn it over to my panel. Thank you.
Good afternoon, Mr. Chair and members of the committee. My name is Erin Perrell, and on behalf of the Frederick County State's Attorney's Office and the Maryland State's Attorneys Association, I'm here to testify in support of Senate Bill 721. As a prosecutor in the Special Victims Unit, I work primarily with children and adults who are victims of physical and sexual abuse. In my 18-year career as a prosecutor, I can say without question that victims want to feel safe and to have closure. Victims of these serious crimes who want a permanent protective order have to wait long after the conclusion of a guilty plea or a trial to obtain the protection they seek. We tell them you must go home, you must wait to file, you must remember to file. To obtain this relief, prosecutors must obtain a conviction and term of imprisonment of at least 5 years. And even after that, a permanent protective order cannot be granted until after the defendant has served 1 year of that sentence. What that means is very few people qualify for relief under the current statute, and those who do may miss their deadline to file. I recently prosecuted a sexual assault and rape case. The defendant in that case raped his wife in the shower. He strangled her. He beat her. He violated not only her body, but her mind, telling her this is what she deserved. She was a whore. He promised to ruin her life, to contact her boss, her co-workers, her family, and friends. She wanted to leave this marriage safe and do it safely. The defendant was willing to consent to a permanent protective order in order to avoid a longer prison sentence. Allowing defendants the option to consent to a permanent protective order promotes victim safety and resolution of cases. Defendants and victims alike will benefit from the passing of this bill. Victims will receive the security and protection of the court, and defendants may avoid the risk of trial or longer sentences. We urge the committee to give Senate Bill 721 a favorable report.
Good afternoon, Mr. Chairman, Madam Vice Chair. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're also here in strong support of Senate Bill 721. The crossfile was reported out favorably from Judiciary Committee, I believe, yesterday. And I'm going to echo what was said before, but I also just want you to think about what we're asking victims to do. They're not only reporting, coming in, testifying, or supporting a guilty plea where you get a conviction and then you get a conviction, a term of imprisonment for at least 5 years, but then they have to file again 12 months later, come back, see the offender again. It's really, it's very onerous. This is a very onerous process. So what we're saying is that if everybody consents, so these are not contested cases, everybody consents, let there be a permanent protective order. This is especially helpful in child sexual abuse cases because we don't want to put kids on the stand if we don't have to. And this would allow prosecutors to come in and say, let's have a long period of protection. Let's still have a conviction, but let's not have to bring the kid back, have to have the family come back to court. It really is a simple bill, and I usually don't say bills are simple, but this one is. So for these reasons, we ask for a favorable report on Senate Bill 721.
Excellent. Thank you very much. All right, we have one panelist joining us virtually, and then we'll open it up for questions. Are both Lori Ruth and Margaret Tian? Okay, so we'll hear from Lori Ruth and Margaret Tian. Margaret, good to see you. Welcome. You're up.
Hi, everyone. I'm Margaret Tian. I am an attorney and a partner in the law firm of Etheridge Quinn in Frederick, Maryland. I've been an attorney in Maryland for over 30 years. I practice primarily criminal defense. I occasionally represent victims and witnesses in criminal cases as well as criminal defendants. And I was actually the victim's counsel for the case that Ms. Pearl testified about in Frederick County. I represented the victim, and when I represent a victim, I put the same energy into that representation that I try to put into representing defendants. And this woman, as Ms. Pearl said, really just wanted her ex-husband to permanently stay away from her. When we looked at the family law article, consent is not one of the grounds for a permanent protective order. As someone who is often the defendant's counsel, I'm not offended by changing this to allow state's attorneys and defense counsel and victims counsel to negotiate, because sometimes we may want a permanent protective order for a case where perhaps there is less than 5 years incarceration imposed. And I certainly think that the requirement that a petitioner has to wait until a respondent has served a sentence of 12 months under the current law is unduly onerous, as Ms. Jordan was testifying to earlier. So for all of those reasons, as someone who represents generally criminal defendants, but occasionally victims, I would support this bill and urge the committee to give it a favorable report. Thank you.
Thank you very much. All right, we'll hear from Ms. Ruth.
Good afternoon, Mr. Chair, members of the committee. My name is Laurie Ruth. I am the Public Policy Director at the Maryland Network Against Domestic Violence. I'm sorry I can't be there in person. We also strongly support this bill. It's funny, I remember when the Permanent Protective Order was passed originally, it's got to be 10 years or so now, it's very onerous to begin with for anybody. But certainly if parties are willing to consent, it makes perfect sense to allow this. There's just no reason that anybody can come up with why we would not want to encourage that and be able to offer it. So for those reasons, we urge a favorable report. Thank you.
Excellent. Thank you very much, Ms. Ruth. Questions from the committee? All right, seeing none, thank you all very much. Thank you.
Thank you.
With that will end the hearing for Senate Bill 721. We'll now move on to Senate Bill 828. Hey, how are you? All right, before we get started, I'll let the committee know that there is actually a set of amendments that we've worked out and worked in consultation with the Attorney General that I do not believe you have before you, but the bill's fairly simple, and I'll explain those amendments as we walk through the testimony, but I'll make sure that the committee has an interlineated copy of the amendments after my presentation. So I just want to make sure that the committee knows that. So don't necessarily work off of the initial bill. All right, so Senator, for the record, this is Senator Smith here to enter into the record Senate Bill 828. Now, our session began, was controlled, the specter of our session was kind of, going to be controlled and continues to be controlled by two main elements. One is obviously a $3 billion budget shortfall, and then also the new administration in Washington, D.C. And as it relates to immigration and the current administration, it's no secret that the current administration has promised to deport roughly 11 million undocumented immigrants currently in the United States. The administration has been very clear in its intentions to start off with those with criminal records or suspected criminal involvement, and then broaden the aperture slowly to include folks that are what they call collateral folks, that people that are friends, relatives, associates of those who would be suspected of criminal activity. And as that aperture broadens over time, the administration has been ever more clear about its intention to go after everyone here present who is undocumented in Maryland and throughout the United States. This is happening in Maryland, make no mistake about it. It's been very clear. And we can all agree that we all want safe communities. We can all agree that any sovereign nation deserves to have a safe and secure border. And for national security reasons and various other reasons. We all agree on those things. We can also agree that the vast majority of people that immigrate to the United States come here for a multitude of different reasons. Some come here seeking greater economic opportunities. Some come here seeking refuge from unsafe or inhumane circumstances. Some come here to secure a better future for the next generation. And although folks are of varying statuses of immigration, when they get here, they become part of the fabric of our community, mixed families. Some people are born here. Some people come here under protected status, haven't seen their native country in years, decades. So we've got this mixed tapestry of immigration in the United States. And I think all of us here know that we've got to secure borders and we've got to do back-end reforms. But we've also got to make sure that we as Marylanders protect our communities and protect our neighbors, our classmates, our coworkers, and our families. And that's what this bill is about. Now, that's the humanitarian part of the equation. And I want to speak a little bit about the economic piece of the equation as we face that $3 billion structural shortfall. In Maryland, immigrants play a crucial role in the economy, contributing as workers, entrepreneurs, consumers, and taxpayers. They strengthen communities in a wide range of fields, from biotech and healthcare and education to seafood processing and all of the like. Many immigrants take on some of the most demanding and dangerous jobs, and as I mentioned earlier this week, that was exemplified by the tragic collapse of the Francis Scott Key Bridge on March 26th, in which all 6 construction workers lost their lives, and they were all immigrants from Latin America. Immigrants have long bolstered Maryland's population. As we face a fiscal crisis or fiscal challenges, I'll say, our population shrinks. We talk about this, and we talk about the state of our economy all the time. But immigrants have helped bolster our economy and bolster our population. Over the past decades, in the face of our natural population decline and increased domestic out-migration, immigrants have been the source of stability for our state. And as of 2022, immigrants have represented about close to 17% of our state's population. Immigrants are more likely to participate in the labor force in the U.S. than U.S. or Maryland-born residents. This is particularly meaningful in the current economic climate as Maryland struggles with a labor shortage, which began in the midst of the pandemic. As of 2023, immigrants represented 21% of our labor force. Immigrants make up over 50% of the workforce in several occupations, including home health aides, taxi drivers, housekeepers, and carpenters. They also make up 23% of science, technology, engineering, and math, STEM workforce, and 23% of the nurses in Maryland. There are more than 100,000 ITIN filers in Maryland, and they pay more than $100 million in net state and local personal income taxes, and that's after their refunds annually. And in a recent report, the American Immigration Council estimated that in 2021, Maryland's combined population of immigrants paid $13.3 billion in federal, state, and local taxes and had a total spending power of about $33.1 billion for our economy. So the bottom line up front, as our comptroller mentions in her testimony, Maryland cannot afford to lose its immigrant community. So what does this bill do, and why is it needed? This bill, as amended, requires and ensures that the Attorney General develop and publish guidance regarding immigration enforcement at sensitive locations to inform the public and relevant state agencies about the limitations on federal immigration enforcement activities at sensitive locations, the responsibilities and the restrictions on state agencies that affect the agency's ability to ensure compliance with the federal and state law while also maintaining public safety and accessibility. And then on or before October 1st, which is the effective date of the bill, our state agencies will have to implement that policy that's consistent with the guidance that's issued by the Attorney General. That's what the bill does as amended. Sensitive locations under the bill are listed as a public school, public library, a healthcare facility operated by the unit of the state, a shelter, or any other location that provides state-funded services related to physical or mental health, education, or access to justice. And so with that, Mr. Vice Chair, members of the committee, I would ask the committee for a favorable report. This is just one small step in the suite of bills that we have before this committee to address, I think, some of the very, very valid concerns of those folks that serve alongside of us in the classroom, in the workforce, and as our neighbors, and in many cases, our family. We always talk about One Maryland. This bill helps ensure that we keep everyone here safe, secure, and we ensure that we have a vibrant and welcoming Maryland for everyone. So with that, Mr. Vice Chair, I'll rest and I'll cede it to my panel and stick around for questions.
Good afternoon. It's a pleasure to be here, Mr. Chair, and yes, Mr. Chair and Mr. Vice Chair are the same right now. Members of the committee, for the record, I'm Comptroller Brooke Learman. I'm here to speak in support of SB 828 and thank the sponsor for bringing this bill. As he noted, I'm here to talk about some of the economic consequences of immigration in Maryland. I recognize a lot of those statistics. Thank you. Maryland is fortunate enough to call itself home to some of the most robust international communities in the nation. Our major metropolitan areas have been ranked among the most welcoming in the nation for immigrants. 17% of all Marylanders were not born in this country, and yet they have chosen Maryland as their home in the United States. However, if our immigrant communities cannot feel safe in their schools and their playgrounds at our state agencies, we could lose them. And as somebody who keeps an eye on our labor force participation and our revenues, this is concerning to me. Last year, my office released a first-of-its-kind report that assessed the state of Maryland's economy. And while we face many challenges, one consistently positive note was the role that international immigration plays in keeping our state economy moving forward. We then did a follow-up report that further explored the impact of immigrants on our economy. And I think that most, if not all, of the statistics that the sponsor shared were from that report. A few notes here. First, our workforce. Immigrants in Maryland make up over 20% of our civilian labor force. And just to keep that in mind, they are 17% of our population, over 20% of our workforce, which means they are really punching above their weight in Maryland in terms of workers. The benefits of our strong immigrant communities can be felt in almost every industry, from our crab processors, almost all of which would need to shut down without immigrants, to the healthcare sector, where immigrants make up over 24% of registered nurses and over 55% of home healthcare aides in Maryland. Second, and this is especially relevant given the budgetary concerns we've all been following, our state revenue is dependent on the taxes paid by our immigrant communities. In 2022, immigrants in Maryland paid over $5.3 billion in state and local taxes and contributed over $6 billion to social services programs such as Social Security and Medicare, and had overall spending power of over $30 billion. So our concern is anything that could risk losing our immigrant communities or pushing them out or making them feel unwelcome at a time when our economy needs them. Finally, like I did for the Data Privacy Act, I want to note a non-economic reason, but one that I find important as an executive. And that is that this bill will help create a standard across sensitive locations across the state, including in state agencies. That way we can be sure that those running sensitive locations, those running state agencies are all performing from the same playbook. We are all using the same rules and the same tools so that wherever somebody goes, they have the same answer. This is important for many reasons, but one, to make sure our state employees, like those at our branch locations across the state, and other state agency locations across the state, have certainty and understanding of what they are required to and need to do. Thank you for your time, and I urge a favorable report on SB 828.
Thank you so much, Chair Smith. Vice Chair, members of the committee, thank you for the opportunity to testify today. My name is George Escobar, and I'm the Chief of Programs and Services at CASA. And on behalf of our members, we urge your strong support for Senate Bill 828. The Protecting Sensitive Locations Act is about dignity, safety, and ensuring that every Marylander, regardless of immigration status, can access critical services without fear. For well over a decade, federal policy restricted ICE activities in schools, hospitals, other essential spaces to prevent intimidation and protect access. But that policy has been rescinded as of January 20th. ICE has the green light to operate in places where families seek health care, where children go to school, and where people practice their faith. Some may point to recent ICE statements claiming they won't enter schools, for example. Well, that's reassuring, I guess, for now, from a single individual. The reality is that we cannot rely on verbal assurances. And without protections in place, sensitive locations remain vulnerable to enforcement actions. Maryland families deserve certainty. As one of the largest multi-service providers in the state, CASA has firsthand knowledge of the chilling effect this fear has had. Parents are afraid to take their children to school. Patients skip doctor visits. Worshipers hesitate before entering their places of faith. Through our RAID hotline, we have documented surveillance near workplaces, schools, and courthouses. Collateral arrest of individuals with no criminal history, detained simply for being in the wrong place at the wrong time, and targeted enforcement against people engaged in their everyday activities. To date, CASA has also trained hundreds of teachers, social workers, and faith leaders who are desperate to protect their communities from these escalating enforcement actions. But training's not enough. What we need is clear, enforceable policy so there is no doubt, no fear, and no question about where ICE's authority stops. No one should have to choose between their safety and their basic needs. Senate Bill 828 provides that clarity and protection. We urge your favorable support. Thank you very much.
Thank you to the chairman, vice chairman, and members of the committee for having me here. My name is Matthew Lopez. I'm an attorney and director of state advocacy at the National Immigration Law Center. When DHS rescinded the Protected Areas Sensitive Locations memo, it changed policy dating back to 2011 that it set clear expectations for the general public and written directions for DHS agents about how to engage in these places that were deemed essential to the entire community. With this lack of clear direction from agency leadership, places like hospitals, schools, and domestic violence shelters have no official assurances that immigration officers will not show up at their doors. What is clear is that ICE is facing intense pressure from the very top of the administration to ramp up deportations, which is not a condition in which to expect restraint. But although policy has changed, the fundamental constitutional protections that govern these locations remain. These protections existed before the inauguration, and they exist now. It is within the rights and responsibilities of any of these sensitive locations to invoke their constitutional rights, and that is what this bill is about. And to be clear, nothing in this bill is in conflict with federal law. Communities across the country have been left confused and unsure of how to proceed in this new environment, and it is within the role of the Attorney General to help Marylanders and stakeholders in the state to understand their rights. This is why you have seen AGs from across the country do similar work, and it is also the state's role to ensure that agencies within its jurisdiction conform with the Constitution. The Constitution and the Bill of Rights are the foundation of our legal system. We should celebrate efforts to understand those rights, and we should be concerned about any agency that thinks it's a threat for people to understand and invoke those rights. Thank you very much for your time.
Good afternoon, and thank you for the opportunity to testify. My name is Sanaya Asfau, and I'm an 11th grader in high school at Montgomery County. I am a member of CASA, and I am also a leader in my student group, Students Fair, a student-led organization fighting for immigrant rights in the county. I am here and decided to leave my classes early today because no student should choose between education and safety. I am here to be a voice for all of my fellow students in Montgomery County and all of Maryland who want to go to school without worrying about ICE. Like many in Maryland, I am the daughter of immigrants. My parents left Ethiopia to build a better life for my sisters and for me. I could learn without fear, access healthcare, and most importantly, feel safe in my community. But for so many students, that security is being ripped away. Just this past month, students have reported seeing ICE just outside their school or at the church just down the road. I know classmates whose parents have been deported. I've watched amazing friends and students stop coming to school because they're afraid. They don't want to come to school and have everything they have been working towards be taken away. We have a right to learn. High school is supposed to be about prom, getting good grades, college applications, and school clubs. And it should not be about worrying if our parents will be there when we get home. It's not just about students like me. When ICE is allowed at hospitals and churches, it forces people to make impossible choices. We talk a lot about life, liberty, and justice in my history classes, but as a country, how can we say we have those values if we don't fight to make these places safe for all of us? I asked the committee to vote yes on the Sensitive Locations Act because, once again, no student should have to choose between education and safety. Thank you for your time.
Thank you so much. Sanaya, where do you go to school? Or you don't have to tell us if you don't want. I was just curious.
Okay. That's kind of personal, so sorry.
Oh, sure. Got it. Okay. Senator West.
Yes.
I have to start by apologizing. I have to step out. I think I missed your discussion of the amendments. So if I ask you something, it's probably about the amendment.
Sure.
So
let's make sure, hold on, let's make sure you're on the mic. Let's make sure. No, no worries.
I thought it was.
There we go.
Okay. There we go. Thanks. I notice on page 2 of the bill, at the end of the listing of all the sensitive locations, there is any other location designated by the Attorney General. Is that the subject of an amendment?
Say that one more time.
Sure. On page 2, at the end of all the locations listed as sensitive, the last designation is any other location designated by the Attorney General. Have you amended that out of the bill, or is that still in the bill?
So yes, that now reads any other location that provides, and if you're, I've got an interlineated copy, so the lines are not going to be the same, but this is on page 3 after line 11. So the amendments strike everything on page 3 from line 1 to 11, okay? And then you have the sensitive locations definition, and then as determined by the Attorney General requires special consideration for immigration and enforcement activities. The Attorney General shall develop and then publish guidance. So that portion that you're referencing is no longer in the bill.
Okay. So there was a subsection B which talks about how the Attorney General should develop guidelines.
That's right.
The section I was referencing was just before that. So you're saying that's been amended out? Or in your proposed amendment, that would be amended out? The language, any other location designated by the Attorney General?
So that's out.
That's out.
Yeah, so Roman 2 now reads, as determined by the Attorney General, requires special consideration for immigration and enforcement activities.
Okay. So don't need to ask you about that. But let me ask you about the rest. Isn't this sort of a feel-good bill? Because let's take courthouses, for example. They don't stay open all night. People who are concerned about being apprehended can't live in the courthouse. Once they go in, they have to come out. Wouldn't it be possible for ICE to stand outside the courthouse? You say they already, I think you mentioned that they already surveil places like that. Mm-hmm. Can't they surveil the person going in and then have the people standing outside ready to apprehend them as soon as they exit the building? So
just to be in all candor, to address, you'll see that the judiciary did offer some testimony, and they objected to be included in the bill because of separation of powers issues. And so they're no longer included in the bill.
So you amended them out too?
They're amended out.
Okay, well, let me substitute for a courthouse, a place where a funeral, graveside ceremony, rosary wedding, or other religious or civil ceremony or observance occurs. So, couldn't ICE just surveil people as they arrive at the ceremony and then bring enforcement officers to present, and as soon as the ceremony is over and the people are dispersing, arrest the person after the ceremony concludes?
So that is also amended out. but I think what your questions do raise a good point. So the bill now is under the state agencies, right? State agencies, and as the comptroller ended her testimony, that you would have policy and guidance that was consistent across all state agencies. And so that's really what's left in the bill, and I can read you the list really quickly. But your line of questioning does, I think, elucidate a very important issue as to why this is not a feel-good bill, and it's actually a substantive bill for informational purposes, because there is a difference between an administrative warrant and a judicial warrant. And when you're operating a private space, and you've got immigration attorneys here that can help flush this out, but the difference between an administrative warrant, which is issued by essentially a bureaucrat within the Department of Homeland Security, does not allow you access into private spaces and or public government spaces. You need a judicial warrant for that, issued by a judge, by a federal district court or state court judge. And so that is important to understand for government agencies and for, yes, private sector, which this bill doesn't cover, but that education piece is very important. The bill calls for the Attorney General to just issue that guidance and for the agencies to adopt policy, not regulations, policy, to ensure that every state government official understands those types of differences when interacting with a federal immigration enforcement officer.
All right, well, let's assume that the ICE agent goes to the federal court and obtains a warrant from the federal court to enforce the federal law.
That's right.
And then goes to a location in Maryland. Do we have the power to prevent the serving of such a warrant and the apprehension of the person?
No, we do not. And the bill does call for, again, the limitations on federal immigration enforcement at sensitive locations, but also the responsibilities and the restrictions on state agencies that affect the agency's ability to ensure compliance with federal and state law. So that guidance is going to be pretty clear. Obviously, there's an issue of federalism there. Federal judicial warrant allows you, again, to go into those private spaces and then also into those government agencies.
Can I
Absolutely.
interject?
She's got personal.
So I just want to sort of emphasize the two bills that I've testified on, the Data Privacy Act and this one, are very similar in one regard, in that the Data Privacy Act was about making sure, in my mind, as just speaking as like an executive of an agency, making sure that all agency executives, that we are all treating data in a uniform way, as we are units of the same state government, right? This bill does that for our locations, right? So that my branch office managers understand the guidance from the Attorney General and are treating folks the same way that the MVA branch managers are treating it, so that no matter what agency it is, because we are all one state government, there is uniformity across the agencies in complying. Because you could, imagine a situation where an agency manager is either too strict or not strict enough about what they allow. And so this kind of guidance will be really helpful for us to make sure that we're following the law, that we are doing only what we need to do, which is to follow the federal warrants and to make that explicit and uniform across every agency.
Okay, I'm totally with you on that. Thank you for that clarification. There's no question that we need to have one law which applies uniformly across the state to all state agencies, so that we don't have different interpretations in different parts of the state and different treatment of these situations. Couldn't agree with that more. Let me just finish with the sponsor. So is there anything left in this bill which says that ICE cannot go into certain sensitive locations that are listed, like churches? No, it's all gone. Okay. All right. Thank you very much for that. And I do have a question for the controller.
Yes.
So this continues my line of questioning when we had the other bill on the data.
Yep.
From a couple of weeks ago. You indicated in response to my question that Maryland this past year received $14 billion of money from the federal government. And my response was, as people around here probably, I'm sure, are aware, I'm no fan of Donald Trump. I've never carried water for him, but he was freely elected by the American people as President of the United States. And as we saw last week in his meeting with the President of Ukraine, if you push back, if you push him, he's going to push back. And he's a counterpuncher, he's going to push back harder. What will Maryland do if we pass this and the data legislation, and he concludes that Maryland is doing everything it can to obstruct his effort to do what he believes he was elected by the American people to do, and he decides to punch back and to take away from Maryland that $14 billion? How would we respond to that?
I think it's an important question and consideration, Senator, but I was elected by the people of Maryland and not by Donald Trump. And so my duty is to Marylanders first and foremost. And so I think that legislation like this is important to ensure that we're protecting Marylanders.
So you think this policy is important enough that we should disregard any possible consequences that might be visited upon us by the federal government under the leadership of the current President of the United States?
I can't, I don't think any one of us knows on any given day what the U.S. Secretary of Transportation is planning for his grant-making process, or what the President of the United States or Vice President of the United States is planning, what guidance they're planning regarding grants. But I think, my job as comptroller is to make sure that I'm representing the people of Maryland to the best of my ability, and to provide you all with data around the economic activities that immigrants, or the economic positive benefits that immigrants bring to our state. And so that's what I'm here to do today.
Thank you for your answer.
Thank you.
Thank you so much. Senator McKay.
Thank you, Mr. Chair. Sponsor of the bill question. So you had given a laundry list of, did you see the pun? for
The
dry
laundry
cleaner, the
I
laundry
like
list.
that. That's good.
The laundry list of immigrant statistics. And in those statistics, did that make up illegal immigration? Or was it legal immigration? Or was the statistics more generic?
They were a blend of the two, so generic in that sense.
Was there any thought of looking in percentage-wise of illegal versus illegal?
I'm actually not quite sure you could actually delineate between the two. I'm not sure we have access to that data, and I'm being told by the comptroller that it's impossible to delineate.
So while this bill is more specific on illegal immigration, because ICE would be looking for those people who have fallen into that bucket, would you say that those statistics are just generic as in immigration as a whole? And hasn't that been the policy of the United States for many, many years as the great melting pot?
I think the statistics include people of various status, and the point for including them and incorporating them, one was kind of the humanitarian aspect of immigration in our state, meaning that immigrants participate in every facet of life and are your neighbors, are your classmates, are your coworkers, and are your family. That's one aspect. And then to weave in the economic impact, which includes both legal and undocumented immigrants, to show the economic contribution and the, I think, economic importance and essential contributions that immigrants have made to our economy, especially in this very austere moment. And so that's what those statistics were used to highlight. The bill ensures that we adhere to federal and state law. And so just like the data privacy bill, you will have to adhere to state and federal law. You will have to get a judicial warrant to enter into these places. And the bill ensures that, again, as the comptroller and the panelists have spoken to, that there's a sense of uniformity of understanding as to where those bright lines are. And that's used to protect everyone and to ensure public safety, but also to ensure that folks that are here working a job, going to school, paying taxes, contributing meaningfully to our economy and to our society are understanding of their rights and have their rights protected just as anyone else in the state.
As regards to the immigrant statistics, I am actually, while it is 3 generations, but I am. Would that be included in the immigrant statistics?
No, these are foreign-born folks that are here, some of whom have been here for decades, but foreign-born.
Okay. While this law, if it is passed, is going to deal with the Attorney General, who will create the guidelines, my question is, will this apply to anybody else who violates federal law?
How do you mean?
It seems, while regardless of it being good or bad, we seem to be picking on a particular piece of federal law that we've decided we don't want to have an extra layer of protection.
I don't think there's anything wrong with ensuring that our state agencies adhere to federal law, and federal law necessitates certain hoops to be jumped through before you enter into certain spaces and conduct certain activities. To ensure that everyone is aware of those rights, I think, is a very good thing and consistent with the Attorney General's role as the chief law enforcement officer, but also as the lawyer for our state agencies. That's consistent with that mission.
Okay, and last of all, Madam Comptroller, this is more of a statement. It is not to have more debate with you or anything like that. But the word "take issue" is probably too strong. But yes, ma'am, you were elected by the people of Maryland, and that's all the people of Maryland, including those people who did vote for the administration. Oh, yes. And so And I know that you, and I understand that, but the policies of the federal government, there are people in Maryland who did vote for that. And I know that you meant no disrespect to them or whatever, but I thought it was important that I acknowledge that. But thank you, Madam Comptroller.
Thank you. Any further questions for the sponsor, for the comptroller, for this panel? All right, thank you all very much. We'll go to our next panel. In person, I have Councilmember Odette Ramos, Haley Sparks, Morellis Urbano, Stephanie Wolf, and Viviana Westbrook.
Hi, good afternoon, Mr. Vice Chair, members of the committee, and once again, I am on my tiptoes to see over this. I forgot where the little stoop is. My name is Odette Ramos. I am the Baltimore City Councilwoman for the 14th District. I am here to let you know that the Baltimore City Council passed a resolution recently unanimously supporting this bill. And the reason that we did that is because we believe strongly in our diversity of our city, and that the immigrant community is absolutely one of the greatest parts about that. And so our population, while it is steadying, but the growth of our population is happening because of our immigrant community, no matter the status. And so we wanted to send a strong message to our community that we want them to be safe. We want our communities to be safe. And as the first Latina elected in the Baltimore City Council, it is also really important to me that I am not the last. And so that we have community members who feel like they can also participate in our city, get the services from our city, be able to enjoy themselves at church, be able to go to the places that everybody can go to, and be a part of city government. So it was very, very important to us that we passed this resolution. And I'm asking for your support of this bill to send a strong message to our immigrant community that they are important Marylanders, that our community is welcome in our state and in our cities, and that we want to keep them safe and we want them to be here. Thank you very much for your time, and I ask for a favorable report with amendments. Thank you.
Hello, my name is Dr. Haley Sparks, and I am here on behalf of the Maryland chapter of the American Academy of Pediatrics to express strong support for the Protecting Sensitive Locations Act. As a primary care pediatrician in Maryland, I proudly care for many children from immigrant families. I have witnessed firsthand the devastating impact of the rollback of federal protections for sensitive locations on children's health. I could share countless examples, but today I will highlight just one. Several months ago, I began caring for a previously healthy little girl who suffered severe brain injury after being thrown from the vehicle in a car accident. I will call her Maria. Due to her injuries, Maria now uses a wheelchair and a feeding tube. But with the appropriate therapies and medical care, she is beginning to recover, recently even taking her first steps since the accident. However, a few weeks ago, Maria's mother abruptly canceled all of her daughter's appointments and took her out of school. When I reached her by phone, she stated she was terrified to bring Maria in for medical care because ICE would take her from the clinic. The window for Maria's brain recovery is closing. Without continued therapy and treatment, it is very possible she will never walk again. She will never eat by mouth again. She will never reach her full potential. Maria is not alone. Every day, our clinic receives calls from families, many of whom have been our patients for years, who say they will no longer bring their children to clinic because of fears of ICE. This fear has serious public health consequences as well. Children are falling behind on routine vaccinations, increasing the risk of outbreaks of preventable diseases in Maryland, like measles, and the outbreaks we are seeing in Texas and New Mexico, I think, speak to how serious that is. When you consider this bill, I urge you to think about children like Maria, a little girl who, after enduring an unimaginable tragedy, deserves her best chance to heal without fear. Thank you.
Good afternoon, Senators. My name is Viviana Westbrook, and I am the state and local advocacy attorney at Catholic Legal Immigration Network, otherwise known as CLINIC. As the nation's largest charitable immigration legal services network, CLINIC provides substantive legal and program management training and resources, as well as advocacy support at state, local, and national levels. CLINIC supports SB 828, the Protecting Sensitive Locations Act. This is of particular importance because we do not wish to see any more of the chilling effects that the rescinding of this policy, the protected areas policy, has already had on immigrant communities accessing essential services. It's important to note that back in 2021, CLINIC worked closely with DHS and a coalition of other organizations to make the expansion from sensitive locations to protected areas. We'd heard about too many violations already occurring in certain areas that were not originally included in sensitive locations memorandum, as well as violations of the existing ones at that time. Because of this, CLINIC wrote and sent a transition paper to the Biden administration about the importance of including more areas. Now, both policies had exceptions under which immigration enforcement could still arrest someone. When this policy was rescinded on January 21st, 2025, DHS issued a press release that just talked about criminals going and hiding out in certain of these locations, but that had never been the case, that had never happened, and there were always exceptions that permitted ICE to do this enforcement. And so because of all those previous exceptions, it did beg the question as to why this policy was actually rescinded. There's now in place a common sense approach, but this doesn't take into account biases that we all have. It does not sufficiently protect immigrants, and it did not protect them previously, and it's not going to protect them now. The protected areas policy is necessary. Having the sensitive locations expanded to courts and to places of worship and elsewhere is essential. So we urge you to vote SB 828. Thank you so much.
Good afternoon. My name is Morelis. I am a proud senior at an HBCU in Maryland. I'm not here only as a student, but also as a Black immigrant myself and a leader in my community. I am here to urge you to support Senate Bill 828, the Protecting Sensitive Locations Act, to ensure that we are limiting ICE access to our schools and college campuses. This spring, I will walk across the graduation stage with a degree in multimedia journalism and Latin American studies, a moment that once felt impossible to me. Today, I am here not only for myself, but for the more than 10,000 undocumented students currently enrolled in colleges across Maryland who also dream about walking across the graduation stage. My fellow students work tirelessly to build better lives, contribute to society, and pursue higher education despite living under constant fear. History warns us about the consequences of denying people their right to education. Maryland once tried to ban education for Black people after Nat Turner's rebellion. The Alabama Slave Code criminalized teaching enslaved individuals to read. Jim Crow laws deliberatively blocked Black Americans from pursuing higher education. In response, HBCUs were founded as a testament to the undeniable right to learn, showing that education is a right and not a privilege. As we face a similar moment today in history, I ask you all, not as politicians, but as servants who represent all of us, will we allow history to repeat itself by creating an environment where undocumented students are too afraid to pursue their education? Allowing ICE in sensitive locations like our schools opens the door for racial profiling, fear, and intimidation, not just for immigrants, but for all students of color. Colleges and universities should be sanctuaries where the next generation of leaders can flourish without fear, not places where students are forced to look over their shoulders. I urge this committee to stand firmly on the right side of history. Protecting students' rights to an education is not just a policy issue, it is a matter of human dignity and human rights. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Stephanie Wolf, and I'm the Director of Immigration Services at the Maryland Office of the Public Defender. We urge a favorable report on this bill. However, I learned a few minutes ago that courthouses have been removed from the latest draft, and I hope that we can continue to work with the sponsor to ensure that courthouses and other locations that are essential to access to justice will remain covered. Courthouses are physical spaces that house a number of state and local agencies, and access to justice services. It is not simply the courtrooms that are included. And courthouses have to be safe for everyone if we're going to accomplish real justice there. If some people must fear that any appearance in court carries the threat of detention, family separation, and exile, then we are not offering safe and equal justice to all. Over the last several weeks, between the rhetoric of mass deportation and the reality of changes to immigration enforcement policies, our own institutions have begun to feel increasingly dangerous to our non-citizen clients. I've received inquiries from public defenders around the state wondering if and how they should reassure their clients that it's safe to come to court. And that is not just criminal defendants, that includes the parents of juvenile respondents, clients who wanted to pursue post-conviction relief to correct a constitutional error but were afraid to do so, minor traffic defendants, and more than one person who wanted to take advantage of a specialty court but was afraid about the repeated court appearances that would entail. Undocumented Marylanders are not the only people who are afraid. I could give you a number of examples of people who are not legally subject to an ICE arrest, but have expressed to their attorneys fear of coming to court because ICE could be in the courthouse. That shows that the perception is important here. The perception that courthouses are unsafe can spread throughout the community and broadly chill engagement with the legal system. We'd urge a favorable report with that amendment.
Excellent. Thank you very much. Looking forward to working with you. Further questions or any questions for this panel from the committee? Okay, excellent. Thank you all very much for taking the time to testify. All right. Wendy Frosch, Laura Garcia, Sarah Polk, and is Reverend Dr. Kevin Slayton Sr. here? Whoever would like to start first.
Good afternoon, Mr. Chairman and committee. Thank you for allowing me to testify. My name is Wendy Frosch, and I'm here as a health policy consultant, excuse me, and a longstanding advocate for access to healthcare services. I also serve as a board member for a federally qualified health center and for Planned Parenthood of Maryland. Both of these organizations provide a broad range of health care, from primary care to specialty services, often to individuals who face multiple barriers to accessing care. In both settings, our services are available regardless of an individual's ability to pay or their immigration status. And these services are provided in a culturally sensitive manner to improve accessibility and with compliance with treatment options. The importance of protecting patients where and when they seek care cannot be underestimated, because when people feel that seeking care might put them and their families at risk, they often opt to skip the care they need. While we may not be able to quantify how much fear can affect one's health, we do know that fear or stress is a contributing factor to many chronic illnesses. And we know that the fear that prevents an individual from seeking care may ultimately result in calamitous health consequences or death. Timely care is essential, not just to individuals, but to their families and ultimately to our communities. The health of our communities depends on the health of the residents, and delayed care can have deep and lasting impact. We need to do our best to make sure that care is available when and where it is necessary. SB 828 will help us protect our community. Thank you for your time.
Excellent. Thank you very much.
Good afternoon. I am Dr. Lilia Stephenson. I am the Chief Medical Officer for Planned Parenthood of Maryland. Thank you for allowing me the opportunity to speak about something I feel very strongly about: providing safe, legal, and accessible spaces for patients to receive the care they need. As many of you are aware, the last few years have been especially challenging for those who advocate for, provide, and need reproductive health care. As a physician, it is my duty and privilege to assist those seeking care. I began medical school by learning the tenets of health equity, and on my graduation, all new doctors took the Hippocratic Oath together. These ethics of the provision of health care are the cornerstone of practicing medicine. When we treat patients, we don't care who they are, because they are human beings who deserve the human right to health care. This is not purely a moral argument. If our patients are scared to seek care because of their immigration status, perceived or actual, that has an immeasurable impact on the health of our community. When patients fear for their safety in any capacity, they do not seek care. Not seeking care can lead to serious public health issues. For example, HPV can turn into cervical cancer. People can unknowingly carry and spread infections. People may be forced to carry unhealthy pregnancies and die because of an ectopic pregnancy. All of these are preventable. Additionally, when community members are afraid for their safety, it further affects our ability to operate undeterred. This can lead to challenges with staff retention, as our staff is already fearful. Patients are already expressing anxiety, which our staff need to take the time to address when we could be focusing on other healthcare concerns. Furthermore, not instituting protections for sensitive locations such as healthcare centers would create a culture of fear and stress in a workplace environment that is not sustainable for anyone to work in. If there were raids at our clinics, this would hurt patients and staff, as we would have to immediately shut down our operations. For this and many other reasons, we strongly support SB 828 and respectfully request that the committee vote favorably on this bill. Thank you for your time.
Hello, thank you to the committee. My name is Sarah Polk. I'm a general pediatrician. Most of my patients are Latino children and immigrant families. Almost all of my patients are U.S. citizens, while one or both of their parents is an immigrant. At the end of a recent visit, my 9-month-old patient's mother thanked me for taking such good care of her and regretted that she would not be seeing me again. Confused, I asked her to clarify. She told me that she did not feel safe coming to visits, as healthcare sites weren't safe anymore. She did not intend to come back for the foreseeable future. I encouraged her to reconsider, but could not offer her any assurances. This mother is not alone. Anti-immigrant rhetoric provokes fear and reduces primary care visits on the part of immigrants and their families. We have evidence of this from a Maryland healthcare system which saw a 43% decline in pediatric primary care visits for immigrant children, coinciding with threats related to the public charge. While threats about the public charge had limited practical implications, the threats led to fear, which was very real, and harmful consequences, including avoiding healthcare. Healthcare access is important for child physical health and development. Pediatric primary care is critical for health promotion and for the early detection and treatment of health and developmental problems. Regular access to pediatric care sets kids up on a path to a healthy and productive adulthood, which is good for children, their families, and our communities. The Sensitive Locations Act would allow pediatricians and other healthcare providers to reassure immigrant patients and families of their safety in clinics and hospitals and encourage them to seek care when needed. Doctor-patient relationships are built on trust. I cannot offer patients false reassurance. Probably ICE won't come doesn't make anybody feel good. For my 9-month-old, I'll just have to hope her mom brings her in when she turns 1. An important part of the 1-year visit is the measles, mumps, and rubella vaccine. An unvaccinated child died of measles in West Texas last week, the first death from measles in this country since 2015. Death from measles in the United States is a preventable tragedy. The Sensitive Locations Act will protect health care and health and prevent tragedy. Please stand up for children. I urge a favorable report on the Sensitive Locations Act for my patients and for our communities.
Good afternoon, Mr. Chairman, members of the committee. My name is Kevin Slayton. I pastor Northwood Uphold United Methodist Church in East Baltimore. And I've come before this committee to share the cry and the unified voices of over 215 faith leaders in our state. In our respective roles and faith traditions, we are all in support of immigrant justice. Together, we are focused on a shared principle of faith, one that calls us to stand with the stranger and to love our neighbor as ourselves. And so we've signed our names on the line urging this body to protect immigrant communities. Even one of your own, Senator Muse, has joined us. And while we believe in the moral and ethical laws that govern our daily lives, we are ill-equipped to handle the legal challenges that so many of us will face. That's why this legislation is important, and we hope you will consider adding churches, faith institutions back to the language. This bill will provide the guidance that we so desperately need to ensure that we don't jeopardize our tax status or our nonprofit status. So I want to say that the First Amendment of the Constitution, as many of you know, protects one's right to practice their religion. And I come before you to say we've been practicing since 1791. With that much practice, we ought to know by now that you should treat others the way in which you want to be treated. And so I close and I leave you with the written scripture from my faith, the Christian faith, Deuteronomy 24, 17, 18, which says these words: "You shall not deprive the resident immigrant or the orphan of justice, for you should remember that you were once in bondage in Egypt, and the Lord your God redeemed you. Therefore, I command you also to do this." I make that statement because as an African-American preacher, and I know my time is up, it's important to remind myself of the history that whenever white Americans chose to be at their worst under the banner of Christianity, they often went into black spaces, particularly churches. I only need to tell you about 16th Street Baptist Church in Birmingham, Alabama. 4 young black girls were blown to smithereens, or more recently, 2015, in Charleston, South Carolina.
Thank you very much, Reverend. Welcome.
Good afternoon, members of the committee. My name is Laura Garcia, and I am a nurse practitioner, primary care provider, and the Chief Medical Officer for Healthcare for the Homeless in Baltimore. Thank you for the opportunity to speak for Senate Bill 828, the Protecting Sensitive Locations Act. I've worked for HCH for the last decade, and over my tenure have delivered care to many immigrants, both individuals and families, who are unstably housed. Since the rescission in January of the previous policy protecting specific sensitive locations from immigration enforcement, we are already seeing significant consequences, especially in terms of patient behavior and their concerns for safety. The anxiety and fear that immigrants are feeling is considerable. This only compounds already complex physical and psychosocial health issues for these unstably housed patients. We have seen higher no-show rates, fewer scheduled visits, and more reliance on telehealth since January that reflects a sense of instability and lack of trust in the system. When call center staff speak with patients, they only affirm this concern. The fear of deportation outweighs the need for care, non-urgent and urgent. When patients delay care out of fear, they're much more likely to end up in emergency situations that are more costly and difficult to treat. Increased DR utilization is not only taxing for the healthcare system, but it also creates worse outcomes for patients. The guidance the Attorney General has given to medical clinics like mine has been invaluable, and all potential sensitive locations would benefit greatly from similar guidance. This would allow for a more standardized and hopefully broader interpretation of the protections across these locations. We can and should afford these individuals and families. Many of my patients access services at multiple locations, such as schools, various state agencies, churches, courthouses, and social services establishments. Having all of these service providers following the same rules allows for fear to be mitigated. We urge a favorable report on Senate Bill 828 to support my patients in being able to access medical services without fear. Thank you.
Excellent. Thank you very much, Ms. Garcia. Questions from the committee? All right. Thank you all very much. Thank you. All right. Is Robert Nunez here? Mark Gaither? Rena Shaw? Is Rena here? Hey. Is Krish Finarasha here? Oh, yeah, again. You want to come on up? Ashika. Virtual, that's right. Okay, that's right. All right. She's not in yet then. Aaron, and then we'll go to Elaine. Okay. All right. Welcome.
Thank you. Good afternoon, Chair, Vice Chair, members of the committee. Thank you for the opportunity to speak in favor of this bill. My name is Mark Gaither. I am a 35-year educator, 15 years in the classroom, 20 years. It's been my honor to serve at Wolf Street Academy in Baltimore, Maryland, PS 23. PS 23 has served immigrants coming to Maryland for 172 years. It was one of the first schools in Baltimore, and it served generations of folks from different countries around the world that has made Baltimore great, that has gone on to make Maryland and the United States great. And I believe that we ignore the mental health, the fear, and the chilling effect that the rescinding of the Sensitive Areas Act or policy by the federal government, we ignore it at our own peril. The parents of my school make calculations every day, calculations to keep their families safe. Now, this bill says that we want guidance. I want to be able to say to my families, this is the situation. This is what I can do, and this is what I can't do. And the bill specifically says that we will not do anything that violates state or federal law. But having the guidance to give to my families so they have the assurity that what I say is correct is essential. And it is true. I believe the senator earlier was asking about whether immigration enforcement could happen after somebody leaves one of these areas. This bill does not address, to my understanding, those areas. But we need to be able to say to them, when you are here, these are the rules that you will live under. Thank you.
Good afternoon, Chair Smith, members of the committee. I'm Reena Shah, the Executive Director of the Maryland Access to Justice Commission. We support SB 828 and request a favorable report. We strongly believe that courthouses should be designated as a sensitive location. They should be part of this bill, and that ICE arrests should not be permitted in and around the state courthouses. All Marylanders use courts to protect themselves and their communities from harm and to exercise fundamental rights. In addition to judicial proceedings, courthouses provide victim services, self-help centers, housing counseling, local government services, and more. For these very reasons, the Supreme Court has recognized time and again that obstacles, physical, monetary, procedural, to fully accessing courthouses are intolerable. Access to courthouses and therefore access to justice must be preserved. We know that judge and attorney safety and security has been something that this committee has addressed recently due to the death of Judge Wilkinson. In the same vein, we must ensure that people using courts, the litigants, perceive courts as safe, neutral, and accessible. Here's some data from the first Trump administration. In 2019, the Access to Justice Commission published a report that documented 70 ICE arrests that happened inside courtrooms, hallways, parking lots, often in public view, which undermine the perception of courts as places of safety and justice. And this is the effect that it had. People did not pursue legal remedies, with almost 500 survivors of domestic violence and sexual assault not seeking protection. Witnesses avoided testifying. Opposing attorneys threatened to call ICE as a tactic and detained individuals. Missed court appearances, and this undermined the fair and efficient administration of justice. So we have already been through this, and now without the federal protections, we know we'll see more of this, and for that reason, we urge a favorable report. Thank you.
Thank you, Mr. Chair. Ms. Shaw. Yes. I have to go back to the podium. Sorry. I really appreciated your testimony. I think of all the sensitive locations covered by this bill, the courthouse stands out. I think it's unthinkable that a state law enforcement official would have the right to go into a federal courthouse because of the differences between the federal government and the state government under the U.S. Constitution. Similarly, I think it's unlikely that the courts would hold that a federal official has the right to go into a state courthouse when the state courthouse people in charge say you can't come here. So I really want to thank you for pointing that out. Of all the various locations in this bill, I think that one has federal constitutional significance. Would you agree?
I do think that courthouses should be included as a sensitive location. Yes,
Thank
Senator. Thank you.
That certainly brings up interesting issues. I mean, look, we'll work with the judiciary. I mean, obviously, significant 10th Amendment implications and the such. But Mr. Gaither, if there are no further questions from the committee, I just wanted to just put something on the record with you. Just if you could come to the podium, a couple questions. So you're, what grades do you teach?
Pre-K through 5.
So what, can you just talk a little bit more about, I just wanted on the record for people to hear, just about your experiences as of late in your conversations with families and also our very young students.
Sure. So it's been difficult. We lived through it during the first administration, and we've been living through it again since January 20th. There are crises that have faced us that our community has been able to come together around. We have an attendance problem right now. We have, at Wolf Street, we have had what I have thought of as a climate of hope over the years, over my 20 years there, because we have a high immigrant population. We have families who come to America seeking life, liberty, and the pursuit of happiness because they feel that here is better than there, wherever there may be. For whatever reason, they wanted to leave there and come here. That created, for most of my tenure at Wolf, about a 96 to 98% attendance rate for our daily attendance rate for our kids, which particularly in urban areas across the country is a pretty amazing thing. Right now, we are struggling to hold on to 92. We dip on days that there is a rumor that there is immigration action going on in the city into the 60s. It is not necessarily the case that it is, we're not coming to school because we think that ICE is going to be in your school, but it is the unknowns that they could be in our school. And while we can say here, yes, we need a judicial and not an administrative warrant, that is not something that I can hold out, that I can put a stake in the ground to without a bill like 828. We have a robust mental health support system at Wolf Street, mental health clinician from Johns Hopkins, interns, and we have been fielding questions of fear, questions of instability, questions of uncertainty, not just from our recent immigrants. We have a large Latino population, many of whom are fully documented. Over half of our staff is Latino. But under the current condition, I've had conversations with staff members about fear of what happens if somebody stops them, on the way into work and asks them about their paperwork. They're graduates of American universities, generations old, but the fact that they feel vulnerable affects what happens at the school. I got into education because I believe it is the fundamental grassroots revolution. If we get this right and go blueprint, we will make a stronger state, city, state, and nation. But we cannot do the job that the Maryland Constitution tells us to do if we do not have clear guidelines on what we're allowed to do and what we're not allowed to do. Thank you.
Thank you, Mr. Gaither. Thank you very much for that context. I think that's amongst the most tragic aspects of these new policies. So I appreciate you putting that on the record. Sure. Thank you. Okay, further questions from the committee? Okay, thank you all very much. We're now going to turn to our panelists who are joining us virtually. We have Now I know, they think Krish Vinaraja is piped in. She's here. And Erin Camp Mansour, she's here. Okay, and then is Elaine Wilson here? Okay, great. So we're going to start with Ms. Vinaraja. Is she here? Is Krish? Oh, here we go. Yeah. Okay, Ms. Vinaraja, you are up next. If you want to come off of mute, we're ready to go. Welcome. Although we can't see you yet. All right, well, while she's loading in, we're going to switch off to Erin. Welcome.
Good afternoon. Good afternoon, members of the committee. My name is Erin Camp Mansour, and I'm a member of Patapsco Friends Meeting, which is a Quaker faith community in Ellicott City, and a partner congregation of the Christ Church Interfaith Refugee Ministry. I'm also a member of the faith-based advocacy group Quaker Voice of Maryland. We advocate for policies that are just, compassionate, equitable, and respectful of the inherent worth of every person. Quakers and friends from other faith communities across Maryland have shared with us their deep concern for immigrant protections. In fact, more than 200 faith leaders like myself have signed on to a letter of support for stronger immigrant protections to ensure the safety and well-being of our communities. We see SB 828 as an urgent priority in response to the recent rollback of the federal policy of protecting sensitive locations like places of worship from immigration enforcement actions. Testimonies are what Quakers call the ways we have found to live and act based on our beliefs. We embrace the knowledge that all persons are children of the divine and brothers and sisters of one another. Our spiritual and social testimonies, including those of peace, community, integrity, and equality, lead us to submit this testimony supporting SB 828. In addition, a coalition of Quaker meetings recently filed suit in Maryland federal court to block the change in federal policy. On February 24th, the U.S. District Court of Maryland issued an order blocking the Trump administration's policy that enables immigration officials to enter houses of worship indiscriminately. However, the order, which outlines the ways in which the Trump administration policy is likely to violate religious freedom and expression rights, applies only to the plaintiff's houses of worship. So I'm a Quaker. They apply to my houses, a group of Baptists, and a group of Sikhs, but only them. And none of these protections include schools, healthcare facilities, or state agencies. The Attorney General needs to issue guidance limiting immigration enforcement access to these essential spaces. State agencies must develop clear policies to enforce and communicate this guidance. No one should be afraid to go to school, seek medical attention, or practice their faith because they lack immigration documentation. We urge you to issue a favorable report, including places of worship, for SB 828.
Excellent. Thank you very much. All right, we'll now switch off to Ms. Vinaraja. Welcome.
Thank you so much. Good afternoon, Chairman Smith and esteemed members of this committee. My name is Krish Vinaraja. I am the president and CEO of Global Refuge. We are a leading faith-based and national nonprofit dedicated to serving children, refugees, and other immigrants. We operate all across the country, as well as in Mexico and Guatemala, but we are proud to be headquartered here in Baltimore and in Maryland. Our mission is to help newcomers fleeing danger and seeking refuge so they can build a better life for themselves, their families, and their new communities. But being a productive member of society becomes impossible when you can't go to a hospital for fear of being detained. It becomes impossible when you worry about your kids attending school or dropping them off in the morning. It becomes impossible when you can't go to your church or your synagogue or your mosque, when you can't seek help after suffering abuse or violence because you worry that your life's going to be turned upside down and you're going to be separated from your family and your community. This bill is crucial in ensuring that's not the reality we live in. The passage of this bill would mean non-citizens can safely go to the doctor when they're sick, that they can go safely to school, that they can escape abuse and attend court hearings. Passing this bill is not just the right thing to do, it's the smart thing to do. It keeps families together, it ensures non-citizens can go to work and contribute, and it means greater stability for all that call Maryland home. I urge the Maryland Senate to pass this bill so they can support a more positive future for all of those who call this state home. Thank you.
Excellent. Thank you very much. All right, now we'll hear from Ms. Wilson.
Hello, good afternoon, and thank you, Chairman Smith and Vice Chair Waldstreicher, for allowing me to testify on this very important bill. I am a co-clerk of Friends Meeting of Washington, a Quaker meeting in Washington, D.C., which is a member of Baltimore Yearly Meeting, the regional organization of Quaker meetings in this area. I live in Silver Spring, Maryland, as do many members of my faith community living in Tacoma Park, Hyattsville, and all around the area in Maryland, the DC area in Maryland. In my letter to the Washington Post published on Tuesday, February 5th, I declared my objection to the new presidential administration's policies on immigration as being at odds with the core ethics of the prophetic Jewish tradition and the teachings of Jesus. Friends meetings all over the state regularly welcome anyone who chooses to come worship with us. We recognize that there is a divine light in each person, and so each life is sacred and worthy of care. We are a community with no clergy. Every member present is in effect clergy to each other. There are several members of our meeting who are no longer comfortable coming to worship with us in the light of new presidential actions on immigration. In fact, I just spoke this Sunday with a member of our meeting who is very fearful about coming to meeting. This means that we as a community are deprived of the ministry that they offer us when they are present with us. I write in support of Senate Bill H-28, Protecting Sensitive Locations Act. No one should hesitate to go to an emergency room, attend worship services, or go to school or college for fear of immigration enforcement. These places should be able to establish policies that limit immigration enforcement on their premises. We at Friends Meeting of Washington are developing such policies for our own building, and we will not allow ICE or other federal agents to enter the building without a judicial warrant for enforcement work. I urge a favorable report on Senate Bill H-22.
Thank you very much, Ms. Wilson. Questions from the committee? All right, seeing none, thank you all very much. Have a good afternoon. All right, with that, I believe that's the final witness. And with that, that'll conclude the hearing for Senate Bill 828. We'll now move up to, thank you all very much. Thank you all. Senator James is not, she's testifying in another committee. We'll do Senator Folden. Do you want to go next? So we're now going to go on to Senator Folden with Senate Bill 735.
Okay. Thank you, Mr. Chair, Mr. Vice Chair, esteemed colleagues of Judicial Proceedings. For the record, William Folden, State Senator for Frederick County. For you today is Senate Bill 735, the Real Time for Violent Offenders Act, also known as Jerry's Law. The purpose of this bill is that the earning of diminution credits to reduce the term of confinement would be taken away for certain types of offenses. For example, those who are serving a first or second degree murder, a term for first or second degree murder in the state would not be eligible for the diminution credits, and that the application of diminution credits that equal more than 10% of an incarcerated individual's aggregate sentence for certain crimes of violence. I did want to point out on the, I was looking through some of the testimony, and I noticed that it had an unfavorable for the judiciary, but I don't believe that's accurate. I think it was just a letter of information. So I want to make sure that we're clear on that. Yep. But it's important, you know, we've done a lot for advocating for certain repeals of sentencing guidelines for certain types of crimes, but we've seen the types of crimes that you're going to hear about here in a moment happening where we have victims being violated, they're being murdered, they're being raped. And just recently, not too long ago, the one incident that happened in Baltimore where the subject was arrested and charged with rape. He was sentenced to, I remember it was 27 or 30 years, and then he was reduced down to 15, and actually he was out in a matter of under 8 years, only to go out and burn a victim in Baltimore and then murder the young lady in Baltimore a few days later. These are wholly preventable, and we need to do better. We've advocated for certain resentencing guidelines, and I think that there's justice in that. However, we have repeatedly failed the victims, and it's time to give them the justice they deserve in not allowing certain individuals who are predators on our community and who attack those vulnerable in our community to be able to get these diminution credits because they're clearly not worthy of them, as they have taken lives in many cases, and that they don't get a chance to come back. They don't get diminution service for their being a victim of crime, but their families don't. They live it every day. They're not getting any diminution credits for their suffering either. So with that, I just think that this committee, I would like to see us have a really good, frank discussion about this and the idea that it's time to do things better for the victims. We can't keep re-victimizing the victims. And with that, I would ask for a favorable report on SB 735. Go ahead, come on up.
Mr. Chair, Vice Chair, committee members, thank you for this. Senator Fulton and all your co-sponsors, I thank you. You have a copy of my testimony. I sent it in. Many of you are quite familiar with me. Some of you aren't. Please feel free to read it, and if not, it's okay. The first of last year, I was present in the House hearing when Parvis' bill that Senator Fulton, I'm sorry, I'm Linda Duncan. I'm the daughter of, my mom was murdered in 1990, and I'll bring you up to date. But I was present in the House when Parvis' bill to eliminate using DIM credits towards early release in first-degree rape was presented. And it's the same as the bill, Jerry's Law, that I initially started in 2015. And I've been doing this for 10 years, except for the years for the COVID situation. But in less than 4 months, Parvis' bill was approved. It was Wes Moore's friend, as he has publicly boasted, that got her bill passed within 4 months. It's the same bill that I have been asking you for, just with a different crime situation. Hers was raped. Mine was murder, to eliminate diminution credit used to be towards early release on that. For 10 years, as I stated, I've been coming before this committee and the House to try to get this bill passed. And a lot of times it doesn't even go before the final committee for a vote. My family may not be friends with Wes Moore, but he, just as you members of this committee, need to remember that you all are appointed to serve and provide fair and equal justice to all citizens of this state, not just for some personal friends or family. My family and I want and deserve the same equal justice as the Lepar family. Today I'm asking you to tell me, what will it take to get this bill passed? What are the problems you're coming up with? And I'd like a response to you from that. Thank you.
Mr. Chair, I think we had someone that was supposed to be here to testify, but he actually was not. Kurt Wolfgang was from the Maryland Crime Victim Resource. I'm sorry? Oh, okay. All right. Yep. If you can go to that. Yep.
All right, Mr. Wolfgang, welcome. You're up.
Thank you, sir.
My name is Kurt Wolfgang. I am the Executive Director of the Maryland Crime Victims Resource Center. And we thank Senator Folden for this bill. It is long overdue. As the members of this committee really know, there is a philosophical battle that goes on between those who have some sort of a problem with long-term incarceration of people who have committed serious offenses and those who don't. I suggest to the members of the committee that the answer to that philosophical battle is that it shouldn't be a philosophical battle. It should be a scientific battle. And the simplest, easiest piece of science to look at that affects this matter is recidivism rates. Recidivism rates, even by Maryland's own standards, are better than 30% overall for violent crimes. Those recidivism rates are really incorrect. They don't cover enough time. If you look at the recidivism rates from the Bureau of Justice Statistics, you find that violent crime recidivism rates are more on the order of 60 to 70%, around 50 for murders, and around 60 for sex offenses. It is not, there are so many ways already to diminish a sentence in Maryland that this is just one more hole in the bucket that needs to be plugged up by taking away or diminishing the use of diminution credits to release violent offenders. I have said to you all for many years, as a lot of people raise the issue of how much it costs to keep someone incarcerated, you have to consider how much it costs to release them as well. And that release is not only a financial cost in many different ways, it's an emotional and social cost to release people and then have them recidivate at those rates. So we appreciate the bill and ask you to vote favorably.
Thank you so much. Questions for Mr. Wolfgang?
We have one more.
What is it?
All right, seeing no questions, we'll now move on to the.
Excuse me. I would like an answer to my question. What has been the problem for those of you that have been here before when this bill has come before?
Yeah, so we'll have opportunities for work sessions on this legislation going forward. So
going forward to another time and not now?
That's correct. So we're going to move.
So, Mr. Chair,
Yeah,
I have a request for consideration here. Ms. Gail Seaton is here. Her daughter was murdered, and she came down here just to testify on this today. So I don't know if you'd be willing to.
Yeah, so we don't have you on the list, but if you want to take a couple minutes.
Well, please, just a couple minutes, because I can explain what happens.
That's okay. Come to the podium.
Thank you.
Yeah.
First of all, thank you all for passing Stacy's law, making solicitation for murder a felony in Maryland, because my daughter was murdered in 2005. It was a solicitation for murder. She was executed because somebody else did something, and so this man had her murdered to send a message. And for years we kept saying, wait till you're held accountable. And he goes, nothing's going to happen to me. All I did was pay for it. Well, I went back to school and found out that solicitation for murder in Maryland was a misdemeanor with a statute of limitation of 1 year. So we're grateful for you all for passing the law and making it a felony. And it seems like it's sad that the only person that really knew about it at that time, outside of your purview, was who is now a convicted felon. And he used to brag about it, and we never understood why he would brag about something like this, but he knew the legislation. So he ended up pleading guilty to a second-degree murder and felonious use of a handgun for 30 years. And guess when he was eligible for parole? 7 years. Why? Diminishing credits. So he's behind bars, and he realizes instead of working one job like I'm told I have to, he worked 2 jobs for a full day, in the infirmary in the morning, in the kitchen in the afternoon. So instead of 5 diminishing credits a month, he got 10. He took courses. He took one course 20 times, the same course, and got extra diminishing credits. and he played the system and he bragged about it. So he was actually released in 2019, and he's on parole until 2029. So what did he do 6 months ago? He got pulled over driving in the middle of Ocean City at night, going 70 miles an hour in a 35-mile zone. What did he do this last year? He got pulled over driving on Route 270, going 85 miles in a 35-mile zone. 85 and a 55. And in both cases, he had to be prompted even to pay. He's on probation. What is it going to take? Is he going to kill somebody else before he's pulled back in? We have the laws, and we need to follow through and think about the victims. My daughter can't speak for the impact on her. I now have the beginning of Alzheimer's, and my doctor said that all the trauma that hit my brain and put me into shock is a cause. Who knows? Please think about the victims. Thank you.
Thank
Could
you.
I just say one more thing?
So we have to move on to our opponents. We're going to go to Ms. Stillingham. Ms. Stillingham, please unmute yourself. You're ready to go.
My name is Allison Stillinghagen, and I am an assistant public defender in the post-conviction division of the Maryland Office of the Public Defender, and I am here to urge you to vote unfavorably on Senate Bill 735. First, I do want to note that diminution credits, or sometimes called DIMs, are a well-established part of our current system, and sentencing judges do account for the number of DIMs that a defendant could earn when they are imposing a sentence. They are incorporated into the sentencing process, and they are not a surprise factor to judges, state's attorneys, or defendants. In my division at the Public Defender's Office, we represent a broad spectrum of incarcerated individuals, including those who have taken significant steps to rehabilitate and those who have not demonstrated rehabilitation. Rehabilitation is a primary function and purpose of incarceration. This bill will seriously undermine rehabilitative efforts. Earning diminution credits encourages incarcerated individuals to proactively participate in their own rehabilitation, including education, programming, and employment training. Knowing that this participation will result in earning diminution credits is often the nudge someone needs to take the first steps towards rehabilitation. This bill will also lead to model incarcerated individuals serving longer sentences. Rehabilitation is real, and it does happen for many who are incarcerated in the DOC. There are people who serve long prison sentences and use that time to earn their diploma or even a college degree. They learn a trade, complete programs, and contribute to special projects in the DOC. This bill would mean that a model individual who has had no infractions and has demonstrated that they have rehabilitated and taken advantage of every single opportunity available to them while in prison will be released at the same time as the individual who has a record of violent infractions, took no classes or programs, and demonstrates no rehabilitation. Finally, under this bill, we will see facilities become less safe for both incarcerated individuals and staff. In most cases, the consequences for an infraction is having DIMS credits revoked. This is a motivating factor to stay out of trouble. For all of these reasons, the Office of Public Defender urges you to vote unfavorably on Senate Bill 735. Thank you.
Thank you, Ms. Stillinghagen. Questions for Ms. Stillinghagen? Ms. Stillinghagen, can you address the fact pattern that was raised earlier? It sounds like the gentleman who murdered her daughter repeated classes over and over again, the same class for the sole purpose of obtaining DIM credits. And I was hoping you could address the abuse in the system that appears to be occurring here. That doesn't sound like rehabilitation to me. That sounds like someone gaming the system.
Sure. So, of course, I don't know the details of that specific case or what happened with that individual. I will say that the sort of rules and the regulations for how someone can earn DIMS credits changes. It has become more strict and more limited over time. So currently, the statutes that allow for the earning of diminution credits allow that a person who is serving a sentence for a crime of violence can only earn a maximum of 5 days of good credit awards, good conduct credits per month. For other credits, such as work credits, they will get 5 diminution credits per month. That would be on top of the 5 good conduct credits per month. They sort of get maxed out at 5 per month. So the 5 good conduct credits and then maximum of 5 work or education credits per month. So if there is also a special project involved, an incarcerated person can earn a total of maximum 10 additional credits each month. Again, I'm not familiar with the exact case, but I do know that these restrictions have come into place in more recent years. I will also say within the DOC facility, it's not common for someone to have a very easy time getting multiple job placements. It's often very difficult for someone to get into programs or get placed on a job assignment. And I personally am not familiar with cases similar to the fact pattern presented, so I apologize that I cannot provide more insight to that.
Got it. Okay. Thank you for addressing it. I didn't see that we had one more person signed up to testify. So Benoit, do you want to come up and provide your testimony, and then we'll take any further questions that there may be.
Thank you, and good afternoon, Mr. Chairman, members of the committee. My name is Benoit Shawala. I'm a paralegal with the Office of the Public Defender's Appellate Division. As a formerly incarcerated person who served 21 years and one who benefited from diminution credits, I testify in opposition to Senate Bill 735. First, this bill will greatly disincentivize positive institutional behavior. From the start of my incarceration in 1998, it was likely that I would spend a lot of my life in prison. I became quite disruptive, disrespecting officers, and getting tickets for fights. I was eventually transferred to a higher security prison in 2001. Upon reflection, my remorse, along with the prospect of losing good time, compelled me to refocus on positive programming. I remained infraction-free for the remaining 18 years, earning an associate's degree from Ohio University and a paralegal certificate. These accomplishments opened doors that would otherwise not be open to me had I not changed my behavior. Today, I serve the people of Maryland in part because of the incentives provided by diminution credits. And I urge this committee not to deprive other deserving individuals of the same opportunity. Secondly, I have witnessed firsthand the check the diminution credits often place on potential violent actors. The prospect of losing diminution credits helps promote safer interactions among correctional staff and incarcerated alike. The passage of this bill will only exacerbate an already violent environment, not to mention overcrowding. Finally, my testimony today is in no way meant to downplay the trauma experienced by crime victims or their families. However, I, along with formerly incarcerated individuals, are living proof that diminution credits have a substantial and, in fact, even a transformative effect. So we urge an unfavorable report for Senate Bill 735. Thank you.
Thank you so much. Questions for this witness? All right. Thank you so much, both proponents and opponents. That concludes the hearing for that bill. We appreciate your.
Excuse me. Is it okay if I expound on a question that she couldn't answer regarding
abuse of DIM credits?
Yeah. Yes.
Okay. Consider my question. Let's be brief here, but.
Well, there was mention of getting multiple jobs within the institution. The DOC has directives that specifically bar that. You cannot, and so for example, if I'm going to school, I cannot get a job and go to school. I either have to go to school or get a job. You can't have both of them at the same time. So I just wanted to put that on the record.
I appreciate that. And
thank you.
I don't want to dwell too long on this. We have another bill with lots of witnesses here, but can you comment on the kind of box checking aspect of it? It sounds like you utilize your time behind the wall very seriously and in a rehabilitative manner and in a way in which the DIM credits were intended. But it also sounds from the woman whose daughter was murdered that that inmate was kind of checking boxes in order to accumulate credits in a way that was not rehabilitative. Did you see others doing that? Is there a way for us to figure out how to prevent that while still retaining what you were able to accomplish?
Well, just from my experience, I was infraction-free for 18 years. And I was able to use that time to get accomplishments that I'm still today being able to benefit from and contribute to society. So speaking from my vantage point and many of the incarcerated people that I was in there with, that's a long time to play a game. So I could just speak for myself and speak for those who are like-minded like myself. Of course, you know, being in an environment such as prison, you know, they're not church choirs, you know, so, but I just don't, for me, I did everything I could. Whether somebody else decided to play a game, for me personally, and for those like-minded, what we did, we didn't want to be punished the same way. We don't want to be treated the same way. So those people that are doing good should not be punished because maybe somebody else may be doing what you're suggesting.
Oh, fair point. Absolutely fair. Senator Folden.
Thank you, Mr. Chair. So thank you for your testimony. Thanks for coming out today. So if you served 21 years, how many years of diminution credits did you acquire?
Well, actually, my sentence, because I ended up getting out through post-conviction relief. So I never actually got to go on mandatory supervision per se. The purpose of my testimony today is more to emphasize the deterrent effect.
That's not what I asked, though, sir.
I understand.
So you served 21 years.
Yes.
You brought it up, so
Yes.
I'm asking.
Yes.
You served 21 years. What was your original sentence, and how many diminution credits did you accrue?
I'm not sure how many I ended up accruing. I know that I was restricted to 5 days a month on good time. I had a job, worked in the law library, and we had special project credits. So you get a job in there, it's 5 days a month, plus a special project for certain jobs. So janitor jobs, you get 5 days, but you may get 10 days if you do.
So you could get 10 days a month?
Yeah, you could.
You could get 110 days a year or 120 days a year?
No, not for a violent crime. You get 60 days a month, 600 days for 10 years, over 10 years.
Is the most you can get?
Yes, for a violent offender, yes. That includes the advance.
So you said that you got 10 days a month, though, or someone could get 10 days a month. You just said a second ago.
No, I'm talking about good time. So good time is in advance. Okay, I see what you're saying. So you got good time in advance, and then you have, you know, your work credits.
Correct.
Right.
So
which would be
how much
5
are
days
you
a
actually
month.
accruing a month?
So you end up getting about 10 days a month for that.
So 120 days, so 4 months a year off your sentence.
Yes.
And over 21 years, that's not an insignificant amount of time. So that would tell me that, not including even the good time credit, I'm just talking about the dim cert. On top of that, your sentence was over 30 years.
Yes, my sentence was over 30 years.
So if you got a sentence for over 30 years, that's a pretty violent crime. I'm not saying that people don't have the opportunity to have reformative measures. They do things that were stupid or silly, you know, they shouldn't have done. They feel bad about when they were, you know, younger. I get it. But in the two witnesses that came up here, neither of them get a chance to get their loved ones back. They didn't get a chance for dim credits. They didn't get a chance for good time served. They got a burial plot. And their family has that for the rest of their lives. That one lady, Linda Duncan, she's been coming down. Her mother was murdered 35 years ago. She's been coming down here for 10 years straight. You can come down here and be in opposition to it, but what I'm hearing actually is that you're an example of what could be, right? The success is what you came down here and said, right?
An example of what could be.
What can be, what can be. My question is, what about the victims?
Well,
because for every one of you that has a success story, we have numerous others that are not. And not to mention you got free college, They're not getting free college, right? Did you get free college while you were incarcerated?
I paid for my college.
You had to pay for your college?
Yeah, Ohio University doesn't provide free college.
Okay, so you paid for your college while you were incarcerated?
Yes, I had family help.
Okay, outstanding. And then the other services that you gave, so I admire your resolve. I admire the idea that you took a negative and made a positive out of it and have transformed your life. It doesn't negate that whatever the precipitating factor was, I'm not saying for you per se, because I don't know the circumstances of your offense, but those two ladies don't get their loved ones back. How is that justifiable to not at least get rid of the dim credits or whatever, or minimize it to a 10% instead of allowing someone to come back out like the one lady has, and 7 years later after her daughter was murdered all those years ago? I just don't, it doesn't add up. The young lady in Baltimore that was raped and murdered, guy served just under 8 years. He had a 30-year sentence. How does that add up? It doesn't.
All right.
Yes, sir.
To that?
Please, thank you.
Well, as I said in my testimony, I in no way intend to diminish the experience and the trauma of crime victims and their families. At the end of the day, most people that are incarcerated will come back out.
Most people incarcerated aren't in for first or second degree murder and rape.
I understand that, but also the bill targets
This bill is specifically
violent
about certain groups.
crimes. And it has a 10% cap on demolition credits, which is an effective ban on demolition credits.
On the most violent people that we incarcerate. Yes.
So I think we've got it. Appreciate both of you and appreciate you working through this issue.
Thank you.
Any further questions from the committee? All right, seeing none, that concludes the hearing for that bill. Senator Henson, it looks like we have SB 858.
Thank you, Mr. Chairman. May I bring up my panel as well? Thank you. As my panel gets situated, I believe we have Michael McMillan from Local Union 1300, David Pendleton from SMART, the Transportation Division as well. And then do we have James from ASME?
Unfortunately, he
Okay, we won't have James from ASME, but the panel is assembled. Colleagues, for the record, I am Senator Shanika Henson, Legislative District 30, here to present Senate Bill 858, State Public Transit Service Stations, Exclusions for Assault and Bodily Injury. What the bill would do is it would exclude certain riders from our public transit if those riders have injured or or assaulted someone on our public transit systems. I will acknowledge at the outset, there is some unfavorable testimony from our public defender's office, and then I'm also in communication with MTA. It looks like what the drivers and operators want has some contrast to what the administration wants at MTA, and they've cited some concerns surrounding enforceability. If we are able to identify those riders who do present a hazard to public safety on our metro systems, MTA wants to make sure that they could implement any exclusionary ban with fidelity. The mechanics of the bill are that after those drivers are given notice and riders, are given notice and identified, that if they are then caught on MTA services, it would be a penalty under our trespassing laws. So it would be basically a subset of trespassing laws that prevented those riders. There are tiers of infractions and tiers of exclusion. If it's an assault or an intentional bodily harm, the first offense would be 30-day exclusion, the second offense, 180-day exclusion, and then there are provisions for lifetime exclusions for repeat offenders. Again, I have viewed the testimony of the public defenders. I take very seriously their concerns, and I would be willing to work with them on any amendments to the bill that would reconcile some of those issues surrounding access to the courts, access to justice, making sure that people have transportation who do have obligations under our legal system, and making sure that folks who are offenders also have opportunities for redemption and notice and due process. With that, Mr. Chair, I will turn it over to my panel.
Good afternoon, Chairman Waldstreicher and members of the committee. My name is David Pendleton. I'm the Director for the Safety and Legislative Board for the Transportation Division of SMART. Our members work aboard the MARC commuter rail, and I'm glad to be here to speak on the bill and some of the points that Senator Henson made concerning the bill. Yesterday, we actually met with representatives from the MTA, where we explained that there will absolutely be nothing different as far as their implementation of the bill. They did mention a concern regarding how they're going to provide notice to the public and to the employees. Just so we're clear, the MTA currently do this. We're not asking them to do anything different. It will be implemented the same way. As far as the actual enforcement, again, based on the BOLOs and their delivery methods, it's merely asking that the MTA police will escort them off of the property then and there. We do note the concerns regarding due process and access for passengers who maybe have certain behavioral disabilities. And we actually have already submitted language that we think will fairly process that, including an appeals process for the bans and allowing caretakers to come on board with those passengers. So we do believe we have addressed those concerns, and we do appreciate them being brought to us. I now yield the floor, and thank you very much for your consideration.
Good afternoon, Chairman Waldstreicher, members of the committee. Michael McMillan, President Business Agent for Amalgamated Transit Union Local 1300. I thank you for this opportunity to come before you today. I represent over 3,000 members of the Maryland Transit Administration employees, that is bus, rail, maintenance, and operations. Our members are the front line of the MDOT-MTA. Whenever patrons do not get reliable service, our members are the first ones that get the attacks. They get everything from having liquids from the form of soda or drinks to bodily fluids thrown on them, cursed out, assaulted sexually, physically, mentally. We want to see this stop. This bill will help to do that. One thing that just happened to me just yesterday. I was on my way, I was down here in Annapolis, I was on my way home. I had one of my members to call me last night. We was on the phone for an hour as I took my drive, for about 40 minutes as I took my drive home. She was sexually assaulted on this past February the 23rd. The gentleman got on the bus, he made sexual advances at her, and this is through a closed shell, but it has a hand opening right at the front of the window. He began to touch her hand, touch the steering wheel, touch her leg. She told him that she felt uncomfortable. She did not want him to do that, told him to go sit down. She then proceeded to touch the request to talk, which that is something that alerts bus operation control that she needs help. That signal failed. She then went ahead to touch priority request to talk. That's a second backup. When she hit that button, it went red and it failed. She hit the silent alarm button at that time, which is supposed to go directly to MTA police and bus operation control. That failed. She had no way or any protection during that time but to record what was happening to her on that bus. She was terrified. She just let me know about this last night that it had taken place with her, but we're asking for support and for you to favorable so that these type of things can stop. And you also hear testimony from two other members of mine today. Thank you.
Senator Charles.
So what happened with the systems, you know, when you started breaking down the problems with that? What's happening with the 3 different fail safes that just it failed her?
It was a bus malfunction, you know, during that time and her time of need. And this is something that she was able to take the pictures of. I have the pictures on my cell phone where it shows each time that she tried to use one of those functions to get help to her that they failed on her on that particular day. It's coincidental, I mean, well, not coincidental, but just on that particular time that she really needed it, it failed her. It was mechanical issues.
Wow. Did you guys get that bus fixed at least?
Like
or is that bus off the street so we can make sure that we have ways for our drivers to be protected in the future?
I'm in for my portion of the investigation for that right now, because like I said, she just called me. I just got this conversation with her just at a little bit after 7:30 last night.
How often do you guys run test scenarios on those particular systems?
I'm not sure what the MTA's PMI, what their preventive maintenance measures are for it. I'm not sure how they work with that.
Yeah, I think that's something that we should probably look into also, in addition to this bill, which I support. But I think we should also look into some of those preventative measures and run scenario testing, because if that's happening on one bus, it's probably happening on many buses. And if we put our drivers in buses like this is going to continuously happen if we have creeps on buses doing egregious things like this.
Yes, appreciate it. Thank you.
Senator Muse.
Thank you very much. This is to anybody to help me to understand a little bit better. If one is found in violation of these infractions, then one is, in a sense, prohibited from what? From bus services, from entering a bus, from entering
So basically how it would work is if a person commits assault against an operator or another passenger, they will effectively be excluded from utilizing transit services for whichever stage they're in. The first time being 30, second time being 6 months, and the third time being for life.
Now, with that being the case, and I think it's a good bill. It is a good bill.
Thank you, sir.
Support the bill. My question is, if we look at what happened with the young lady on the bus, everything failed, right? The button, everything failed. How then will you be able to determine when a person boards a bus or comes in, how will you be able to determine if that person is a violator?
So currently the MTA issues BOLOs, be on the lookout. So those photos are posted at stations on the bus, our section on rail where we brief and speak. So these are things that we would actually be actively talking about before we take our mode of transportation out, train or bus or subway or light rail, whichever be the case. And one thing we do want to point out that there is no criminal justice aspect to it. It's all civil enforcement. But these are things that we would talk about before we take them out. We will be well aware of it. And so the front line would identify, and then we would notify the police to come and remove. That's essentially the idea behind it.
Okay. Thank you very much.
You're very welcome, sir.
Just a good bill.
Thank you. Senator Folden.
Good to see you again.
Hey, good to see you. I can't quite get out my mind that Costanza there.
That's all right. It's a good pillow.
You
like that. You can come up, man, and share it anytime. I mean, I like the bill and how it's presented, but you did just say something. I just want to be clear. So you're going to call the police and ask them to remove the person, identify them so that you can take the administrative or civil sanctions, correct?
Yes, sir.
Are you telling me that if one of your drivers or whoever is assaulted, you're only going to pursue civil things? You're not going to pursue criminal things on behalf of your driver?
Well, sir, there's nothing that would prevent the MTA from pursuing criminal charges.
Well, the victim, not the MTA.
The victim, the MTA, everyone. There's nothing preventing them. There's
nothing preventing it now.
There's nothing preventing it now, and there's nothing preventing it if this.
I just want to be clear that there's nothing, like, this is about the civil remedy to allow them to no longer be on the bus and endanger or transportation.
It's all about workplace safety.
Workplace safety.
Yes.
But there is still a remedy that if it's a violent assault, that they'll be able to seek charges if they choose.
Yes, sir, there is. Like I said, there's nothing.
I just want to make sure that that's still what's in place though currently.
Yes, sir, because assault is still a crime under Maryland law. So
just
there's
not changing anything on that.
No, sir.
Thank you.
No, sir.
I have a quick question for the sponsor. Thank you so much for bringing this bill. As Mike and our other friends know, I've been trying to crack this nut for a while now with assault on transit officers, and I think this is why having new senators is good, because you have cracked it, and I appreciate you bringing it. If we decide to move forward with this, would you object if we add in some of our DC area government transit, so WMATA, our friends at ATU 689? You don't have to tell me now. McGeo, which does the ride-on buses in Montgomery County, is that
My panelists would like
Please,
to answer
sure.
that, but from my perspective, I would not mind at all, Senator.
Senator, that's a great question. So first and foremost, the WMATA would like to be included under the provisions of this bill. The problem is the locally operated, the LOTS systems, they have some concerns regarding their ability to actually enforce it, considering that they rely on local police. So in order to include WMATA, we would have to include the LOTS systems. WMATA has already stated that they're going to be implementing a very similar policy to this bill anyway. They just really wanted to be a part of it for messaging purposes. But that's the reason why they're not included in the bill right now, is because of the burden that it could potentially place on the locally operated systems.
Yeah, can you explain that a little bit more, the LOTS system?
It's the locally operated transit systems like PG
the
County's
bus.
the bus, Montgomery County's Ride On, the Carroll County, Anne Arundel County Connector. Those are locally operated systems that just deal in the county. They're saying they might not be able to comply with the law.
Why wouldn't they be able to comply? It sounds like it's very simple.
Well, I think it's because they rely on local police versus MTA that has its own police, WMATA that has its own police. I think that had a lot to do with it. We actually spoke about it yesterday, and they did ask not to be included, basically.
Oh, so they specifically don't want to be included. But WMATA, they have to, they are tied in with the local?
Well, you would have to change the language of the bill. So we would have to change it from state public transit system to just public transit system. And by making it that definition, it would automatically include the locally operated transit systems in the bill.
Well, what if we say state public transit system and WMATA? Keep it very specific.
Well, actually, sir, we hadn't thought of that. WMATA, like I said, WMATA does want to be included. I can certainly reach back out to their representative and ask to follow back up with you.
Okay. Yeah, I think that I know the ATU folks, they'll probably love to have that for WMATA.
Absolutely. I'm sure
on our side. And then we can figure out later on how to add in the local buses.
Yeah, we don't want to do any damage to the bill, so we'll see if we can find a quick way to do it, an easy way. All right, thank you so much. Seeing no further questions, we'll move on to further advocates. Shantice Robinson, Cheryl Austin, James Smith Jr., please.
Hello, ladies and gentlemen. My name is Shantice Robinson. I've been working for MTA for 8 years. On July the 21st of 2024, a passenger aborted my coach. He was supposed to have been paying his fare. Instead of him paying his fare, he asked me a couple questions, but I was looking at him trying to figure out why he was asking me those questions. But then he proceeded to put his hand behind my shield. He picked my drink up, started drinking it. Then went in the back, sat down, put his legs up on the chair, started smoking his hookah. MTA was called. I went inside the subway station because that's where I felt safe at. While I was standing inside Milford Mill subway station, the passenger went back behind my shield after the door was closed, stole my MTA sweater, put it on, took the drink, and tried to hop on the train. BOCC, they shut the trains down, so the passenger couldn't get on the train. MTA police had came. When they came, they gave him a citation for theft and let him go. He was refusing to give his info. He was refusing to give his identification up. They was able to retrieve it. They gave him the citation. 2 days later, which was July the 23rd, I see a passenger running and flagging for the bus. I waited. I didn't know it was the person until the person stepped up on the bus. And he looked at me and he said, "You look like you saw a ghost. I know who you are and you know who I am. I took your shit the other day. What you want to do about it?" Proceeded to lick his tongue. He came over towards my shield, putting his hand behind my shield. At this point, in the neighborhoods, like when you call the police on people, people try to retaliate on you. So I didn't really know why or what he was going to do. He sat behind my seat. After he sat behind my seat, I was calling control. My chest was tightening up. I started not being able to breathe. He sat behind me. antagonized me, saying things like, look at you, you can't even breathe. And, you know, he came up to the front asking me, did I call the police? Because he seen me on the phone, asking me, did I call the police?
You can finish your thought.
Okay, he asked
Yeah.
me, did I call the police? But I said no. MTA said they was gonna have a police en route. That never hit, the police never pulled up in time. They wanted me to stop the bus. I wasn't trying to stop the bus, not knowing. When he seen me on the phone, he came back up to the front. He set his belongings in the front of the bus, like where the heat and stuff come out, and he started putting his hands in his pockets, like, what you call the police? So I'm really holding on, still trying to pick these people up, trying to get to like a relief point so it won't look obvious that I called called somebody to remove him off the bus. When they finally came and removed the passenger from off the bus, I had an anxiety attack. I didn't know how afraid
Ms. Robinson,
I was. Yes.
if you could just kind of conclude with.
Okay.
Yeah.
The passenger seen me months later in July, stood in front of my bus. I didn't let him on, stood in front of the bus with his hands in a finger motion, saying he was going to kill me, he was going to beat me up. Came around on the side of the window, trying to open my window, banging on the shield. Police I alerted MTA. By the time someone came, he was already gone.
Ms. Robinson, thank you.
3 weeks later, he tried to stab my coworker. But I do appreciate y'all for listening. Thank you.
Thank you so much. We appreciate you. I'm so sorry that you went through this.
Good afternoon, Chairman and committee members. My name is Sherelle Austin. I'm a bus operator for the MDOT. I had a recent encounter with a passenger that has been a problem on numerous occasions. This particular day, this passenger did not want to comply with the bus safety rules. He traveled from the rear of the coach to the front driver's area, blowing smoke in my direction while I was operating the bus. When I instructed the passenger that he would have to move to the rear behind the bus safety yellow line, the passenger disregarded what I was saying, and his response was, "I'm about to get off." This passenger stop was approaching. When he noticed that his stop was approaching and the bus came to a complete stop, he steps off the coach, striking the passenger's flat side mirror, causing the mirror to be loose. He proceeded to go around to the front of the bus, slamming the bike rack down, causing it to go off track. He became extremely hostile when he noticed that I was on the phone with Bus Control Center. I was requesting for police assistance. The passenger began to kick the passenger side door, stating that he was going to cause deadly and bodily harm to myself. He was going to shoot me. He proceeded to go and retrieve a dog from the opposite side of the road from where I was parked, with the bus threatening to have the dog to attack me. And just before the police showed up, this passenger comes around towards my driver's side window, attempting to open the window while toting a knife in his left side hand. He's pulling the window, I'm pushing, trying to keep the window closed. We're fighting at the window just to keep it closed. With him displaying this knife, the police then arrive on scene, and that's when the passenger stopped. I'm requesting for a favorable report in this matter.
Thank you for your testimony. I know it's not easy. Senator Charles and then Senator Muse.
I was interested to hear, let you finish what you were saying. So if you can come up and just kind of finalize what you were saying to us.
Basically, bus drivers deal with passengers every day. We get cursed out, but it's never dealing with the same repeated person, right? But what I went through was with the same repeated person from July to October. I had to go get a peace order out on this person. He got a year probation, and he had to stay 60 feet away from me. 3 weeks after he got from the courts, he, turned around and tried to assault, a bus operator. I couldn't go to work. I was out for 6 weeks with no pay because I was afraid. I had to keep going to court every week until he got served with his peace order. So MTA was letting me know their hands was tied behind their back. I have kids. I'm like, what I do? I have to get shot in the head first before something, go on. How many times is a person going to say they're going to kill you?
So quick question.
Yes.
So this guy, he's never put his hands on you, though.
No, he never got to put his hands on me, but he was trying to get inside of my window.
So how do we address that? And it can be any of you guys, because that's not in the bill. Like, she was dealing with threats and other acts outside of somebody actually putting their hands on her. Because with the bill, look like it only focuses on bodily harm or assaults. How do we take account of that to make sure these particular situations don't happen again? So that's one question, and the other is even if this guy is banned, he's banned for life. It sounds as if like he'll still show up, to your bus route and stand in front of the bus and try to intimidate you some fashion. How kicking him off the bus, is that really the only action, or is there some type of criminal penalty the same way Senator Folden brought up?
So, Senator, the reason why it deals strictly with assaults and not threats per se, it came down to certain constitutional issues that, we felt the law could possibly be overturned for that. Don't get me wrong, we certainly would love to have that extension provided, but we just felt like there's the odds are that the bill could be overturned for freedom of speech sort of things. That's what our attorneys advised us on. So we left it strictly to assault, and that's why.
Yeah, the only reason I asked, because that was it was a very strong testimony, but it didn't have anything in correlation to the actual
Sir,
bill.
it's terrible, and I commend my sister for coming up and speaking on that and reliving that trauma. There would be nothing prohibiting the MTA from developing a code of conduct that would address that issue, but from a legislative standpoint, we were advised to stand down on that particular provision of it.
Okay.
Thank you. For the young lady on your side right here, if you will come to the podium, just a question. Time kind of ran out before you finished, and you were saying then that the police came. That's the last thing you said. Was he arrested? Have you ever had any problems with that particular person before? Do you know?
Yes, he was
charged with, and what
arrested.
happened?
He was arrested. Actually, when the police came, I had to inform the police to don't have his back, because his back was faced towards the guy, because he stood there on scene until the police did come. So when the police approached approached the coach, and I opened the door, I had to tell him, you might want to turn towards him because he has a knife. So he, had his hand on his taser. The guy was then, turned all his energy into the police and telling him, take your hand off your taser. I said, take your hand off your taser. His display of hostility became on the police. He no longer had his hostility towards me. He directed it solely onto the police. So the police had to wait for backup, and then they put him in cuffs and took him away to jail.
That's the last time you saw him?
So no, he actually got on my coach 3 days ago, but he did not say anything. I didn't say anything to him. He tend to come on a coach when it's a crowd of people. He'll run up on a coach, so you can't see that it's him until he gets up on the coach where you are.
Okay, thank you.
Thank you. And just quickly, for the people that have testified, did the state pay for your having to go to court to get a peace order or protective order?
No, ma'am, the state didn't pay. I signed like a waiver. They gave me like a free, I guess like when you sign some paperwork, they can allow you to do it for free and like waive the fees.
Oh, so you didn't have to, because you should not have to pay, you're on the job, you should not have to pay for that assistance, so and you did not.
No, ma'am.
Some mechanism was there.
I didn't have to pay, but I just had to show up once a week until he got served, and he got served November the 13th.
And I know there's many stories, but for the two ladies that testified, did this occur while the bus was standing still or moving, or does it happen in both situations?
Both.
Okay. And lastly, I don't think any of this would be tolerated on an airplane while it's sitting on the tarmac or flying. So I applaud the gentleman who said he's trying to abide by some advice that we not run afoul of the Constitution. But when I think about it, this kind of behavior, it doesn't just endanger these women. It endangers the entire bus. Because first of all, they shouldn't go through this mental anguish, and then again, may not be as, attentive drivers after experiencing something that horrible. So I hope you will look at some case law and some procedural stuff that occurs on airplanes or other mass transit, maybe trains, because if it can't happen on a plane and it can happen on a train, I don't think it should happen on a bus. So, but that's my comment, and hope you'll look it up. Thank you.
Thank you so much. Do we have Brian Perry, Jay Johnson, Catherine Hodges?
Mr. Chairman, Ms. Hodges called me just a few moments ago. Unfortunately, she can't make it. She was testifying virtually, not in person, but she actually will not be able to do that.
Good afternoon, Chairman Will Stryker and Senate Judicial Proceedings Committee members. Hello, my name is Brian Perry. I am a railroader with 26 years of service working in many capacities. I am a member of the Transportation Division of SMART and have been for 15 years. I worked as a conductor for both Amtrak and MARC. I am here today urging a favorable report on SB 858. While boarding passengers in West Baltimore Station stop, a man walked up to my fellow conductor and told him that he did not have a ticket and he was going to be riding the train, at which point he was told that he needed a ticket to ride. The man became quarrelsome, grabbed my coworker by the shirt, knocked him into the stairs of the train, and drug him into the train. Then I grabbed him from behind, removing him off of my coworker, and together we were able to restrain him until he calmed down. A third crew member got help from the MTA police. We both sustained injuries and missed months of work. While he was arrested in this instance, but charges were not pressed, this doesn't happen most of the time. Usually the attackers are removed from one train, then allowed to board the very next one. Imagine somebody walking into this building today and assaulting one of you and being allowed to come back day after day after day. It's unimaginable. We face this scenario every day. This bill would ensure accountability. It'd make the train safer for both us and the passengers. It will be a deterrent to would-be attackers, knowing there will be consequences for their acts. I am certain that everyone wants a safe working environment. This bill would do this for us. Thank you for your time, and I urge a favorable report.
Good afternoon, Chairman Will Stryker and members of the committee. My name is Jay Johnson, and I'm a member of the Transportation Division of SMART and a train conductor with 15 years of working service at Amtrak and MARC. I'm here today urging a favorable report for SB 858. While working on a MARC train stopped in West Baltimore, I was accosted by a person with whom I had numerous problems with. I was struck with a blunt object in the back of my head and neck. I was taken to the hospital where I received 3 staples in the back of my head. This assault left me without work for 9 months. Not only was I physically bruised, but I was emotionally scarred, and I'm still traumatized to this day. For 2 years, I sought help from a licensed therapist. Additionally, I had to have plastic surgery to help the scar in the back of my head seem less gruesome. I don't know what happened to the guy that attacked me. The residual effects are still with me, and I dread the thought of running into him again. SB 858 will prevent him from riding on MARC trains ever again. I ask that you please spare the victims of assault the pain of having to relive their trauma by seeing the ones who attack them every day. There are hundreds of public transit workers who were assaulted last year just by simply doing their job. SB 858 will provide a measure of protection for us, all of us. Create a safe environment for the public to commute and for us to serve them in. Thank you for your time and consideration. I urge a favorable report.
Thank you for your time and for sharing your story. Any questions for this panel? Well, before we conclude, let me just say thank you once more. So many failures along the way in these narratives. And that's why I want to kind of especially thank the unions that represent the transit officers. We heard about technology failures, failures of the agency, failures of the police to respond in a timely fashion. But at all points, the union was representing their members and advocating for them throughout the entirety of this process, including today. So I want to thank you.
Thank you very much, Mr. Chairman.
Seeing no further questions, that concludes the hearing for Senate Bill 858. Senator James, I think you have the last bill of today.
Right.
Senate Bill 883.
I'll go up for a long time. No, we're not. All I ask is you don't penalize me if I go quickly, because you're pretty familiar with the bill, and I think I have a resolution too. So Senator Mary Delaney James from Harford County presenting Senate Bill, 883. Appreciate your attention. I know it is late. This bill, you should all be familiar with, almost all, but I think Senator Love is familiar from her work in the House. So let me just start with a couple of comments. Last year we passed the bill, and I worked with, I think the Attorney General had a comment or a concern, and I eliminated it. This year, I didn't get the courtesy of that soon enough, but so I'll address that in a moment. But in any event, my issue with the bill, why I'm doing it is I'm worried about private property owners, parking lot owners, condominiums, people that are, setting aside spots for the elderly, the disabled, and I'm not particularly taking sides about towing companies. But I do think this bill and the concept that I'm about to speak in Maryland comes out of Corbin, that says basically a property owner has a right to be free from trespass. And this bill, if I had to rename it, I would call it the Clarity and Modernization Law regarding consensual towing for trespassers. So we have enormous protections under state law and some even enhanced protections, I think, in Montgomery County, Howard County, possibly Prince George's County, that even make it, give more protection for when a towing company comes in. So this, I think one of the groups of opposition you see in this bill is people who think that this is somehow protecting unlawful towing. It doesn't. It is designed for people and private property owners in the towing companies they engage only with regard to lawful towing. So there are several cases. Cade versus Montgomery County, 1989. Glad to share it. Think it's referenced in my testimony. DeFrank versus Mayor and City of Ocean City, 1985, Fourth Circuit case. And there might be one other that had pretty much upheld the idea that you can tow from private property. And in the DeFrank case, the Fourth Circuit said you could have a lien, but you do have to be cognizant and protect due process and that constitutional concern. So this year, really late in the game, I got the Attorney General's concern, and you'll see it, and I appreciate they're not opposing it, they just have a concern. In order for us to create the statutory or possessory lien, I think they're right that we should add a provision in the bill to provide for very explicit notice that a lien is attaching if you're parking illegally on this property, and an opportunity to be heard and to contest it for various reasons. I was gonna start and do that myself, but I get that that really it would be better if all the stakeholders collaborated. So I would suggest, unless you want to go and let me draft it up, and I would suggest that we allow a work group to be created here under the bill, and I will define it as you have to figure out those post-towing protections that satisfy all the parties involved in this. And with that, I will be quiet, and thank you for your kind attention.
My suggestion for the work group is all the members who are not present. Senator Love.
Thank you, Mr. Chair, and thank you, Senator. I appreciate you're recognizing the many complexities to this, and as you're thinking about this work group and thinking about amending the bill, I would encourage you to talk to Montgomery County, because when we had the bill,
and I talked to Mako today, and I talked to the Attorney General today, and I did not know anything about the litigation in Montgomery County, and honestly, nor am I interested, because what I'm interested in is a balancing between private property owners who want to protect these very important spots for their customers, and then, of course, to the extent that, consumer protection and the owner of the vehicle, they're concerned if there is an illegal tow. I get that. So I think I'm trying to find a balance here. I'm sorry, I interrupt, but I think I can find a balance here. Whether we can draft the balance now, or we'll just convert the bill to a work group, give it a short period of time, hopefully in time that I can just put the bill in next year with what all the agreed language is concerning post-towing protections. Does that make sense?
We can talk offline. I spent a lot of time on this bill.
I saw that.
When I was working on it over in the House, so happy to talk with you offline about
it. It would have been very helpful if the Attorney General, not you, had shared that with me, because their concerns last year had nothing to do with due process or constitutional. I always address serious concerns with the bill ahead of time. Just didn't have that opportunity this year.
Thank you, Mr. Chair.
Thank you, Senator Love. Seeing no further questions, thank you, Senator James. That concludes the hearing for this bill, and that concludes our hearings for today.
I was feeling great this morning, and now